Hi, my name's Leah Jewell, and I'm the Guardian at Litem Program Director for the Legal Aid Society of the Orange County Bar Association. If you've not heard of the Orange County Bar Association, the Legal Aid Society was established approximately 50 years ago by attorneys, and the Guardian at Litem program is administered by the Legal Aid Society. As part of our duties, we recruit volunteers to be pro bono GALs for the children of Orange County. The training topic today is GAL attorneys in domestic relations court, and you will hear about GALs in domestic relations from two speakers that will follow me today. I have been asked to provide a brief overview of the GAL role in dependency court first. So part one of the training will follow this segment, and we hope that you find this training to be informative. Thank you. Decades ago, when the federal government decided to provide advocates for children in abuse and neglect proceedings, it endorsed a model where citizens would bring a common sense perspective to court proceedings and children would not be treated as just another case. Judges needed people to inform them and give them a view of the case from the child's perspective and be independent of the rest of the parties in the case. In many cases, the judges referred to this as having the need to have eyes and ears on the child and provide a child perspective in the case. Children needed advocates who would prioritize their safety, their well-being, and people who would put the child's best interests first. And this was the start of the Guardian at Litem program. Initially in Florida, many of the Guardian at Litem programs reported to the judges, and the judges would say, "They're my eyes and ears, and I want to hear from the Guardian at Litem to know what's going on with the child." This continued for many years, and during that time, the Orange County Legal Aid Society created the Guardian at Litem program for Orange County, where pro bono attorneys would volunteer to be the Guardian at Litems. Elsewhere in the state, there were consistent support from citizens, the judiciary, governors, state, and local representatives, and also charitable organizations who also wanted to support Guardian at Litem programs. So throughout the state, many independent Guardian at Litem programs were created, and eventually there became a statewide Guardian at Litem program. The statewide model is based on volunteers, and there are over 10,000 volunteers today that support and volunteer with the statewide Guardian at Litem program. There are also statewide employees, usually a program attorney, and a child advocate manager who work as a team with the volunteer. And they provide a perspective for the GAL in court and represent the child's best interest. In Orange County, that continues to be the pro bono attorney or a GAL staff attorney if there's no GAL pro bono on the case. We will look at the differences in the two forms of representation, both the Guardian at Litem program statewide with the volunteer team model and also the GAL pro bono attorney model that is used in Orange County. So we will be looking at their court representation to address appointment orders, access to court records, and other records necessary to review the child's case, the role of the GAL in the courtroom, and also court filings. The first step for the Guardian at Litem in a dependency case is to have an appointment order. Typically this happens at the shelter hearing when the case originates. In many cases, DCF might file a non-shelter petition, and if that is the case, you would be appointed at the arraignment, which follows the non-shelter petition being filed. The GAL is appointed by the court to represent the child's best interest and ensure that the child's needs and wishes are addressed by the court. The statutory language is found in Florida Statute 39.822, and it indicates that the GAL may be appointed at shelter hearing or any time after. The GAL is a party to the dependency case, and this court order that appoints you gives you that authority. So you have access to the child's records. You can continue to represent the child's best interest from that day of appointment, and typically we have acceptance of the GAL appointment by individuals. So for example, in Orange County, we look for a volunteer pro bono attorney to accept the case, and that attorney would file a notice of acceptance with the court, alerting the court and the parties that they will be representing the child. And in addition to that, with the other model of representation with the statewide GL program, the statewide GL program offices would look for a volunteer once they are appointed. So they would find a volunteer willing to accept the case, and they would in turn file a letter of acceptance for that volunteer, indicating that that volunteer will be the person representing the child's best interest to the court. Oftentimes, there may not be a volunteer, either a pro bono attorney or a civilian volunteer, to accept the case. So the Guardian Ad Litem program can continue on the case as they have been appointed to represent the child's best interest and may continue to represent the child. The one time where it's most critical to have a GAL appointed on the case is for termination of parental rights. So oftentimes the GAL may ask for discharge if there is no available guardian ad litem to accept the case. However, if the case is going towards termination of parental rights, the Guardian Ad Litem program would then reinitiate their search for a volunteer to accept the case and file an acceptance so that that volunteer would be able to prepare a manifest best interest report for the termination of parental rights trial. The appointment orders also give you access to the child, and it's important that you visit the child and be able to learn about the child's needs and wishes. And it's important to recall that the guardian ad litem is not appointed to represent the child's wishes or desires. Oftentimes there's some confusion about attorney ad litems versus guardian ad litems, and one of the best ways to distinguish between the two is that the guardian ad litem is appointed to represent the best interest of the child, whereas the attorney ad litem is appointed to represent the child's wishes. This is especially important for many of our children who have the inability to speak, the inability to express their wishes. An example might be an infant child or a young child who has not learned to speak. They're unable to vocalize their wishes. And so the best interest attorney, the GAL, is able to observe that child, review their records, speak to other people involved in the child's life, and make a recommendation to the court based on that child's best interest. The same applies for older children, for example, teenagers who might have some mental health issues. They might be on psychotropic medication, they might be receiving counseling, but they're so mentally ill and not receiving the appropriate care without residential treatment. So there's a recommendation a medical professional has made for residential treatment, and the child does not wish to go to the residential treatment facility. They would prefer to stay where they are, to stay in the school that they're attending, and stay with their friends or family. So the guardian ad litem would look at all the factors in the case and make a recommendation based on what's in that child's best interest, not what the child wants. If that child has an attorney ad litem, the attorney ad litem is going to go to court and say, my client, the 14-year-old, wishes to remain in the current placement and not be placed in the residential treatment facility. Whereas the guardian ad litem, on the other hand, would advocate for what's in that child's best interest to get him or her the medical care and mental health treatment that they need, and to hopefully rehabilitate them to the extent that they could return to their normal lives. Access to records is very important for the guardian ad litem's role. The guardian ad litem has the right to inspect and copy records related to the best interest of the child who is the subject of the guardian ad litem appointment. The GAL is an information gatherer, reporter, and reviewer of information. You might want to gather information from the caregiver of the child, the case manager, teachers, daycare providers, doctors, therapists, or anyone else with knowledge of the child. So it's very important to gather this information and be able to use it in your evaluation of the child's needs and include it in the reports that you would file with the court, whether they be oral or written reports. The GL reports to the court and may discuss the case with other parties as appropriate, but keeps this information confidential. So it's important here to know that you should always review the information that's available on the case. To make certain that you're receiving accurate information, it's often good to compare information that you receive from various sources. The most common records that we tend to get are school records or educational records for children that are school age. It's important to know how they're doing in school, what their educational needs are. Do they need assistance at school? Do they have an individual education plan, an IEP, or other types of assistance being provided to them in the school? Are they in need of those services? You would certainly want to attend any type of educational meetings that are being held, such as an IEP meeting. And if you want to request records in advance of that meeting, school meeting, you would do so with a copy of your appointment order and your letter of acceptance. So it's always important to make sure that you have a current order of appointment, that it has not expired, that you don't need to file a motion to extend it. And so when you go to request those records from the school or elsewhere, that you do have that current order to provide. Medical records are really important for children that have special needs. Many of our kids are medically needy, and medical records can be quite convoluted, and it's oftentimes difficult to obtain them. You always want to start with the Department of Children and Families, checking in with the CLS attorney to see if they have those records already. So you can request them through the discovery process if necessary. And if you're unable to get them from DCF, then you can certainly subpoena them yourself or try to obtain the records. I will caution you, they can be very voluminous, and it's sometimes very costly to gather those records on your own. So you want to go through DCF if possible to get those records. Some of the other records that you might want to review for a child would be things such as the Comprehensive Behavioral Health Assessment, the CBHA, which contains the child's family medical history, general history of the family, whether or not the parents were married, how many siblings they have, any mental health history with the parents, any health assessments that were made previously on the child prior to coming into care. It sometimes details whether or not the children have educational issues and might even tell you if there's an IEP or a learning disability. And then the CBHA also makes a recommendation as to what the service needs are for that child. So does the child need counseling? Does the child need tutoring? Does the child need speech therapy? And these are all things that you would want to follow up on as the GAL later on if they've not been implemented and taken care of by the case management team. It's also a great place to check in if you have the opportunity and find out from the CBHA assessor, who's normally a licensed mental health counselor, that they might have some information for you that they didn't put in their report. So you can sometimes call them up and get some great tips on things they may have found out that are not in the report. The GEL is a party to every case where they are appointed, and the guardian ad litem has the ability to appear before the court, motion the court, and file pleadings. This is why for the statewide GEL program, there is the importance of having a program attorney assigned to every case. For Orange County, the guardian ad litem pro bono attorney can appear directly, but for the other volunteers with statewide program, they have to have the program attorney with them in court. The guardian ad litem is a fiduciary and has a responsibility for representing the child's best interest, to hold all matters confidential and diligently pursue the best interest of the child. By statute, the guardian ad litem is responsible for representing the child and advocating for the child's best interests. This includes legal interests and advocacy outside the courtroom where decisions are made impacting the best interest of the child. The GEL is a fiduciary representative of each child, and the representation of the child's best interest is the sole purpose of the advocacy. The GEL shall be present at all critical stages of the dependency proceeding and shall provide reports and recommendations to the court as required by law and in the child's best interest, and take any other actions determined to be in the child's best interest. Using information gathered from the child, the relevant records, interviews with people in the child's life, the GAL team or the GAL individual should identify the unique needs of the child and provide that independent advocacy to meet those needs consistent with the goals established by the legislature for children in dependency proceedings. Some examples are that they have to advocate for permanency for children. Reunification is always the primary goal, and that should take place within 1 year. If the reunification has not taken place in 1 year, the guardian ad litem should be advocating for another more appropriate goal to accomplish permanency for the child. I wanted to speak a little bit about providing reports and recommendations at this point. The guardian ad litem in Orange County is exempt from filing reports other than manifest best interests in TPR cases. But in other counties where the statewide GAL program is present, they file reports for many reasons. They file status reports, they file reports for judicial review hearings, and also file the TPR or manifest best interest reports. So it's important to remember that some of our roles differ a little bit, but our overall goal is just to advocate for the child's best interest at all times. And it's important to recognize that history of the GAL program here in Florida, that the judges see us as the eyes and ears of the court. So these reports are very valued by the court, and they want to have your position and your recommendations for the child's well-being. The role of the guardian ad litem is critically important to our dependency cases. The courts rely on our written and our oral reports, and the court will always want to hear from you about the child's wishes, the child's well-being, and whether it's on the docket or not, you should feel free to bring up these issues. So even if you're there for an arraignment and a parent's attorney may say, well, we're not here today to hear about the child's wishes, the court may wish to hear those wishes. So always advocate for your children at every available opportunity. And remember that the guardian ad litem is presumed to have a prima facie case to be acting in good faith, and in doing so shall be immune from any liability, civil or criminal, that otherwise might be incurred or imposed. And that's Florida Statute 39.822 sub 1. So remember that we need to convey to the court what's going on with the child and advocate for that youth who may need a guardian advocate or a guardianship later on in life. You want to advocate for whatever is in the child's best interest. And it's also important that you be cognizant of the child's ability to communicate with you. Communication with children should be consistent, developmentally appropriate, and culturally sensitive, because we have children that come from all walks of life. As the slide indicates, we're all wonderfully made, but we're all wonderfully different. And so it's important to convey to the court what those issues are sometimes. So if you have a problem or a concern with the case, you want to communicate with the child, you want to communicate with the court, and you also want to communicate with the other parties about what the child's needs are. The guardian ad litem's role is always evolving, and today we are evolving to attend other court hearings that impact our children. We're switching gears to talk about the role at this time of the GAL in other courts. So we interact with legal professionals on our dependency cases and also with professionals in other areas as well. So we are going to talk about delinquency, criminal, probate, and domestic relations. Delinquency cases stem from child involvement in activities for which they can be criminally charged. and they lead to involvement with the juvenile justice system and are sometimes referred to as kiddie court or juvenile court. If a child is involved in a juvenile justice case, they will typically be appointed a public defender, or their parents, if they have the ability, can hire a private attorney. The child's parent and the public defender will determine the appropriate action for the child to take with regard to the case. They sometimes meet with the state attorney to see what's in the child's best interest and whether or not the child should take a plea or go to trial, or possibly if the child can be offered a diversion of some sort. Oftentimes, the case manager will transport a child who has dependency court involvement to their delinquency court hearings because there's no parent available. And so when that happens, there's oftentimes a case manager transporting the child that doesn't know the child, doesn't know about the child's needs. And it's very important for a GAL to be there if your child is the one in delinquency court. An example would be, for example, we have a young 14-year-old male who is sanctioned as part of his sentence in juvenile justice to write essays and perform community service. And he's in foster care, and he has a learning disability. And the case manager, who is acting on behalf of the parent, doesn't know to tell the public defender that he doesn't believe the child can write an essay, or he doesn't think the child can do community service because of where he's placed. And if the guardian ad litem was at that hearing, the guardian ad litem could talk to the state attorney, talk to the public defender, and inform them that this is a young teen who does not have the ability to write an essay, who doesn't have the ability to perform community service. So those sanctions would not be imposed, and the child would not later be facing a possible probation violation. There is always the case where the guardian ad litem may not even know about the delinquency case, but that's why it's important for guardian ad litems to stay in touch with the child's case manager, because the case manager will be informed when there are delinquency actions, and they're usually the ones to bring them to the courtroom. So if you have a good relationship with that case manager, you will usually know about the delinquency cases, and you will also be informed of when the hearings are. You will also sometimes be informed of staffings that take place prior to the child going to court, and you might be able to find out the name and phone number of the public defender that will be representing the child. So it's important to be strategic, to try to keep open lines of communication, and to engage with the people that are in dependency court as well as delinquency court for the best interest of the child you're representing. Some strategies to address children's behaviors are to get them into counseling to address whatever may have led to the action that involved delinquency. And if you can get services for the child, such as evaluations, child studies, counseling, to be completed, then you can in turn share that information with the members of the delinquency court, the state attorney, the public defender, whoever's representing the child in that courtroom, and advocate for the child's best interest, to have an appropriate sanction and to address their case in an appropriate manner. Many times we're fortunate today that we have unified family court, UFC court it's often called, or crossover court, where we have delinquency judges that also serve as dependency judges. So they usually have the children in both courtrooms. So they may already know the child, and they will know you as the GAL and allow you to participate in the hearing, even though you may not be a party to that case. But you can advocate for the child's needs and best interest in the courtroom. The court is typically willing to hear from a guardian ad litem who accompanies the child to court, and I have done so many times and never been denied the ability to engage in the court hearing and advocate for the child's needs. So I urge you to attend those hearings and advocate for the children in delinquency court whenever you have the ability. Criminal court in this context is not referencing criminal activity by the child, but it's where the child is the victim of the crime. Criminal court judges are frequently finding the need to find representation for child crime victims. Many of the cases where children are victims, the children have no parent who considers their best interest, and hence the need for a guardian ad litem. So oftentimes, if there's a concurrent dependency case, the guardian ad litem that's been appointed for the dependency case might accept to be the guardian ad litem for the criminal court as well. Or they might just be willing to go and visit the criminal court with the child and become aware of the issues in that case. In some ways, it's sort of like having joint representation for the two different cases. Oftentimes we have criminal cases where a guardian ad litem has been appointed by the court in the criminal case, and then there will become a dependency case, and we do not have a guardian ad litem on the dependency case. So we might go to that attorney who is already representing the child as the guardian ad litem in the criminal court and ask them to accept appointment in our dependency case. And the reverse can be true as well. An example of such a case would be where a child was sexually abused and the perpetrator is the mother's boyfriend or husband. And the mother is more protective of her partner than her child that's been abused. So since the parent is not supportive of the child, is not willing to, acknowledge that the child is a victim, then a guardian ad litem is necessary to represent that child's best interest. So the guardian ad litem in criminal court would accompany the child to any pretrial activities. This might include a deposition of the child. And so the guardian ad litem would be there to protect the child, ensure that the child is not taken advantage of in any way, and that there were no unnecessary depositions. And with regard to advocating for emotional support for the child, the guardian ad litem might be able to communicate directly with the state attorney to ensure that there's a victim's advocate available, that the child receives counseling, that the child's deposition or questioning, even for trial, is handled in such a manner as to protect the child and provide the child with emotional support. So that might mean having in-camera testimony for the child so that the child does not have to face the parent when they're testifying. It could also be that the child is allowed to have the deposition with only the parent's attorney in the room and not the parent. The GAL is oftentimes called upon to just be that steadfast person there for the child to support the child. We also sometimes see that guardian ad litems in criminal court become involved with the state attorney with negotiating the perpetrator's sentence. An example of this would be a case we recently had in Orange County where the guardian ad litem was able to help negotiate the sentence and negotiated that there be no contact with the child victim, that the perpetrator assist with counseling for the child, in other words, pay for the counseling that the child needed, and obtain therapy for the child. So the guardian can advocate for these services in criminal court through the state attorney as part of a negotiation, or even by filing certain motions in criminal court. And of course, the GAL would have had to file an acceptance in that court prior to filing any motions. So I would encourage you to, if the child that you are the GAL for in dependency court has a case where they are the victim, that you become cognizant of the facts of that case. They sometimes tie into the dependency case anyway, and reach out to the state attorney involved and do what you can to make certain that the child's best interest is represented in both courtrooms. Typically, children involved in probate court have deceased parents or caregivers. The child would need a guardian to assist with advocating for their best interests. Oftentimes, it may be an attorney ad litem, or if there's already a guardian ad litem who may serve for probate as well. Children in probate court sometimes need guardian advocates, and they may have special needs or be aging out of the dependency system. Depending on the child's needs, the guardian advocate may assist in determining their ability to manage their funds, to marry, to vote, etc. The role of the guardian advocate can be plenary, covering a multitude of issues. and it sometimes has very limited scope as well. It might just be receiving a Social Security disability check as the payee and making certain that the child has the money and funds necessary to meet their needs each month. If a guardian advocate is needed, the guardian ad litem, already appointed in the dependency case, may be involved. And that's usually from the standpoint that you'll have a staffing as the child's about to turn 18, determine whether or not the child is going to require that guardian advocate. And if the court determines that a guardian advocate is needed, the GAL would be involved in the process of identifying and recommending the person to serve as a guardian or guardian advocate for the youth. And it's always interesting in these cases because it's sometimes difficult to find volunteers to become the guardian advocate. So there is sometimes a list that is used in various counties and circuits, and other times you as the attorney may actually need to go to some of your friends that are in the bar, fellow members of the bar who may be interested in volunteering in this capacity, and asking them to become a guardian advocate. Most times we have certain attorneys that are go-to attorneys that you would go to and say, hey, I've got another case where we may need a guardian advocate. And even if they're unwilling to take the case, they might have someone else that they know of that works in the probate area, and they could take that role on. But as the guardian ad litem, if you have a child involved in that process, you do want to attend the hearings to be aware of what's going on, and also just to be there to explain what's going on to the child. One of our roles as a guardian advocate is to help communicate with the child. If you've already been on the case for a year or more and you know that child and have a rapport with the child, it's very beneficial for you to attend those hearings. And whether the child's there or not, you can explain to them at a later time, if they're not present, what has occurred and why it's occurring. Furthermore, you might be able to assist the probate court if you're aware of any evaluations or child studies that were done previously, and those records may need to be shared with the court and probate to help determine whether or not the child actually does need a guardian advocate. Again, the overall role of the guardian ad litem is to represent the child's best interest, to advocate for the child's best interest, and whatever court you're in, you can do that to the best of your abilities and be fulfilling your role as the guardian ad litem. Domestic relations is the last topic that I'm going to review, and domestic relations can cover placement of the child, visitation with parents or other parties, emotional support of the child, and other issues. Visitation or time sharing, as it's commonly known now, is usually determined based on the parents' filings in domestic relations, and children's wishes are not usually included. However, the court sometimes feel it necessary to appoint a guardian ad litem who will meet with the child and have input on arrangements requested by the parents. Additionally, the guardian ad litem may need to recommend therapeutic visitation or other counseling services if that would be in the best interest of the child. Occasionally, the dependency guardian ad litem is already on a case, and following the conclusion of the GAL's duties in dependency court, there may be domestic relations hearings. And so the guardian ad litem might be called on to continue in the guardian ad litem capacity in the domestic relations case. Now you're going to hear from two additional speakers following my presentation that will go into much more detail about domestic relations. So I'm going to leave it there. So next we're going to address a couple of questions that have been posed. The first question was, how long have you worked as a dependency attorney? So let me figure this out. I think it's about 16 years now. I started out working for the statewide GL program in Seminole County as a senior attorney in 2012 and worked there until 2018. I'm currently in my second year with the Legal Aid Society of the Orange County Bar Association, And so prior to that, and prior to becoming a GAL attorney, I worked for the Department of Children and Families as an assistant regional counsel. And then later, when they changed their model of representation and created the Children's Legal Services law firm, I continued with them as a senior attorney. There's even a plaque in the Daytona Beach office of Department of Children and Families. CLS's Daytona office has a plaque in their library with all the founding members of their law firm. And my name is on that plaque. And I worked for DCF in Volusia County for approximately 8 years. So I learned a lot as a DCF attorney and very much enjoyed working for them. But I really find that the GAL work is really in my heart and what I love doing. Is there another question? Okay, our next question is, have you practiced in other courts where dependency GALs have a role? Yes, prior to starting to work for DCF in Volusia County, I was a public defender in Volusia County and represented defendants who had criminal charges involving neglect and abuse of children. I also did other types of criminal representation as well for the Public Defender's Office, but I ended up having quite a few cases involving child neglect and abuse. During this time, I got to know a lot of the DCF investigators that worked in the DeLand area where I worked, and got to know a lot about DCF through deposing some of those DCF investigators. And I was also subpoenaing a lot of DCF records. So I learned an awful lot about the Department of Children and Families from my work as a public defender. I also learned about case plans at that time and services that were available for parents. So one of my go-to plea negotiations for those types of cases was to ask that the parents have a probationary sentence and have a requirement to complete their case plan task. And so generally those case plan tasks would resolve what the issues were that led to the criminal incident as well. And so that was a good way to resolve the cases and made sure that my clients got the services they needed and were able to get their kids back as well. I also practiced in the Unified Family Court in Volusia County as a DCF attorney. The Unified Family Court in Volusia County included delinquency cases, so the child cases, parents' divorce cases, and even child support cases. So as a DCF attorney, I would be present and have the opportunity to speak up and engage with the court and all parties on those cases. And I would oftentimes become involved in those other types of litigation. For example, if a father was paying child support to the mother and the mother was no longer the caregiver, I would advocate for redirection of the child support to the current caregiver. Very important as the DCF attorney, you wanted to make certain that your caregiver was able to care for the children, and if the child was entitled to child support, you wanted that child to be receiving the child support. I would also advocate for child support to be ordered if there was none ordered, and I would quite often provide child support orders to the judges in Volusia County, and once the judge signed off on the order, I would then submit that order to the Department of Revenue, which would actually be the agency that would enforce the child support. Currently, I appear in delinquency court with a good bit of regularity. I'm the GAL for several teen youth who have delinquency cases, and so I make it a habit to attend their delinquency hearings. I also attend other matters regarding their delinquency hearings, and I frequently engage with their probation officers, their counselors, and sometimes when they're placed at DJJ facilities, I visit them at the DJJ facility and communicate with staff members at those facilities to make certain that the children's needs are being addressed in their placement. The next question we have is, how many children do you advocate for as a GAL? I'm currently the GAL on 3 cases in Orange County and have 7 children that I represent. I've had as many as 5 personal cases that I've represented children on and represented their best interest. I normally accept cases with teenagers who have educational issues. As an aside, education is one of the issues that I focus on and specialize to some extent in. And I attend a lot of IEP meetings, individual education plan meetings, and love getting involved in making certain kids get all the services they need to improve their educational capabilities, whether that be tutoring, additional services in the classroom, such as having additional time for testing, and many other services that can be implemented on the school level. Right now, though, I have one case which has a baby on it, so I'm very much enjoying having a baby to deal with. Reviewing records such as the child's medical records. The child that I currently have that's an infant has a flat spot on the back of her head, so just recently I did a phone visit with that child, and so I had to ask the caregiver to turn her to the camera so that I could see the back of her head and see that the flat spot is getting better and her hair is actually starting to grow back, which I was very happy to see last week. Okay, our next question is, how do you support a child's request to participate in court hearings? Children in dependency court have the right to participate in all aspects of their proceedings, from shelter to termination of parental rights. And various courts handle this differently. For example, when I worked in Volusia County as a DCF attorney, children were routinely brought to shelter hearings and judicial review hearings. They had the opportunity to speak to the judge at those hearings, and they were also given some explanations about what was going on. You know, if they wanted to go home with the parent, the judge would explain to them why that wasn't going to happen on that day, and that the parents were working towards getting them back. And typically, the child would just say hello to the judge, maybe say that they wanted to go home or say that they did not want to go home. That happens too. And the child would be escorted out of the courtroom, and there was a child's playroom that most of the children would go to, and some of the older children would just be escorted outside the courtroom. And some of the teenagers were actually allowed to stay in the courtroom and hear what was going on if that's what they asked the judge to do. This also provided an opportunity for attorneys to speak to the children prior to the hearing. So as a GAL attorney, I think that would be really great, because you would be able to see the child prior to each judicial review hearing and even the shelter hearings to talk to them. Now, when I practice here in Orange County, the children are not brought to the courthouse, and the DCF attorneys generally ask for them to be excused in advance, and they put that on all their orders that the children are excused, and they usually don't ask the parties for a position. They just say the children are being excused for age or because they're in school or something to that effect. And the court grants the request for the child to be excused unless the GAL or someone else would speak up and say the child wanted to be in the hearing, or that the child needed to be brought inside to speak to the judge, or whatever the case may be. The guardian at Litem can request that the child be brought to court at any time. So if the child has conveyed to you a desire to attend court, then you certainly are going to convey that to the court and ask that the child be present in the courtroom. I typically explain the court proceedings to the children and discuss with them whether or not they would like to attend court when I visit with them. And typically these are older children, so they have the ability to communicate with me and decide if they want to come. And if a child requests to attend court, I generally speak to the case manager and ask the case manager to transport the child, or in some cases I might transport the child myself. However, on occasion, the case management team does not bring the child as you would request. And this just recently happened in one of my cases. So at that hearing, I did object because the child was not present. The child had expressed her desire to be present at all future hearings. And I asked the court to order that the child be transported to the next hearing. And so I'll wait and see what happens later this month if the child is in fact transported. But I'm pretty certain that she will be, since the court did order it. Our next question is, have you had to help children prepare to testify? So yes, I have helped children and prepared them for testimony in court. This is part of your role as a GAL. You generally, as the GAL, know the child best out of everyone that deals with the child. And so you do want to make certain that the child is age appropriate to testify. I recommend that you meet with the child if you have not already met with them to ascertain whether or not they have the developmental and emotional skills that they need to actually testify in court without harm to them. Oftentimes you want input from the child's counselor or therapist or others that are involved with the child about whether or not they think the child is appropriate to testify. And consideration should be given to the comfort of the child. I generally try to make arrangements for the child to meet me at the courthouse prior to the testimony so that I can prepare them from the standpoint you want them to be familiar with the courthouse, to understand where in the courtroom they will sit, who else will be in the courtroom, and explain to them generally what will happen in the hearing where they're going to be called upon to testify. I like, for example, if it's a trial and they're going to be in the witness box, I want them to sit in that witness box prior to that hearing so they get comfortable with it. There are other things you can do to make a child comfortable in the courtroom as well. Sometimes I ask to move a podium so that the podium might block somebody that the child doesn't want to look at when they're testifying. I also arrange for therapy dogs to be available to come to court with the child, and even when I meet with the child at the courthouse, I will request that the therapy dog be there to provide some comfort to the child. And if the child has a good rapport with that dog, I will then request the exact same dog be brought the day that the child will testify. But that's just one of the things that I like to do to prepare the child. You're also going to want to obviously go through what the anticipated questioning is going to be for the child. And I oftentimes invite the DCF attorneys to join me when I meet with the children so that they too can ask the children the questions and be open with the DCF attorney as well as to what I will be asking the child. So sometimes that will allow the child to have fewer questions that they need to testify about. So that's my tip for how to handle preparing a child for testimony. And I think we are out of time, so that will be the end of the questions that I can answer today. But if you have any additional questions, please feel free to email me or call me, and my contact information is available on the documentation. Thank you. This concludes part 1 of the training. If you have any questions about the training, please contact me at the Legal Aid Society of the Orange County Bar Association. The training on GAL attorneys in domestic relations court is next. I hope you enjoy it.
Let's now discuss the issue of greatest problematic commonality between children in dependency and domestic relations cases: domestic violence. Child welfare agencies have estimated that between 40 to 60% of Florida's dependent children are exposed to domestic violence against mothers or caregivers by their other family members. What's more, studies indicate that children who live in homes with domestic violence are at up to 15 times greater risk of experiencing physical abuse than if domestic violence was not present in the home. Throughout the state, legal aid organizations continuously receive the most requests for family law assistance, people seeking a divorce or escaping home environments that are physically dangerous for children and their abused parents, requiring a domestic violence injunction. The victims and perpetrators of domestic violence are most often people a child knows well. The child depends on them to meet their basic needs, and they have a close bond with this person. The role of dependency court and domestic relations court exist in large part to address the needs of a child and parental victims of domestic violence seeking to escape what is often very repetitious violence. Florida Statute 39904 exists in part to ensure that assessing the needs of the state's domestic violence victims and survivors remains at the forefront of our state's priorities. The statute is entitled Report to the Legislature on the Status of Domestic Violence Cases, and it requires the Florida legislature to receive a report on the status of domestic violence in Florida. At a minimum, the report has to detail the rate of incidence of domestic violence, regional domestic violence hotspots, details about unreported domestic violence trends, state programs designed to help victims of domestic violence or DV perpetrators, including a detailed list of the funding, hard data about the number of people who receive services from certain DV programs, and finally, details about domestic violence related deaths. While many dependency court orders often span the life of the dependency case, orders in domestic relations court, particularly those addressing domestic violence with child victims, extend beyond the case. Regardless of the court in which they find themselves, guardians at Litem exist to exclusively serve the best interest of the child. As you continue on with this training, please consider the manners in which GALs may provide long-lasting benefit to the children they serve through securing sound and meaningful court orders.
Hi, my name is Mary Nardi. I'm an attorney licensed to practice law in the state of Florida for the last 30 years. In January of 2019, I was appointed as General Magistrate in Seminole County in the Domestic Relations Division, where I primarily preside over divorce and paternity actions. Prior to my appointment, I was in private practice, where I practiced exclusively in the area of family law for approximately 27 years. My portion of the presentation is essentially to give you a view from the bench as it relates to guardian ad litems. During my years of private practice, I had the opportunity to be appointed as a guardian ad litem in private divorce and paternity cases on numerous occasions. Acting as a guardian ad litem and advocating for a child's best interests was some of my most rewarding experiences as an attorney. As a general magistrate assigned to the Domestic Relations Division, I know firsthand how important and valuable a guardian ad litem's input and opinions are to the judge tasked with the enormous responsibility of rendering a decision based upon the best interests of children. As a judge or magistrate presiding over contested issues involving a child or children, it's very often difficult to ascertain where the truth, or should I say, reality lies. Without the input of a neutral third party such as a guardian ad litem, the court is left with testimony of each parent in a he said, she said scenario. The important role of the guardian ad litem is to gather facts and, just as important, impressions based upon your factual interviews and review of relevant documents. Although a guardian ad litem may be somewhat restricted in reporting exactly what a child may report to a guardian ad litem, a well-crafted report and prepared testimony can provide the court with invaluable information. Verifying factual information is crucial. However, an effective guardian ad litem will not only provide factual information, but explain how that information is relevant based upon the factors as set forth in Florida Statute 6113. And those impressions and conclusions you reach can also be based upon what a child may have reported to you. It's okay to tell the court that you were provided information from a child which helped you formulate your impressions and recommendations without the necessity of reporting exactly what that child said. As a guardian ad litem, it's very easy to get caught up with collateral information provided to you from each parent as well as their witnesses. It's extremely important to know where to put your focus and attention and not spend a lot of time reporting information that's not specifically relevant to the best interests of the children and the 6113 factors. And it's okay to ask the parties, what is the relevance of that information as it relates to the factors? The judge is going to hear a lot of collateral information from each parent who will want to present that information at trial. And often, that information may or may not be helpful to the court in rendering a decision. It will be extremely valuable for the guardian ad litem to sift out that information the court is going to want to hear and not get caught up with unnecessary facts and very often emotional drama that the parents will want you to report. So in conclusion, be thorough, keep copious notes and records, and sort through the relevant from the unnecessary information based on the 6113 factors, and that way your impressions, conclusions, and recommendations to the court will be extremely helpful and persuasive to the judge or the magistrate.
Hi, my name is Tanesia Hall, and I'm a family law attorney with the Legal Aid Society of the Orange County Bar Association in Orlando, Florida. I have been with Legal Aid since 2001, and I have served as a guardian ad litem since 2008. This portion of the training will discuss guardian ad litems and domestic relations cases, the different stages of the case, hearsay, and special considerations. Let's go through an overview of the different types of domestic relations cases and the different stages those matters have in court. Here we have a list of the more common cases in domestic relations court: adoptions, dissolution of marriage, injunction for protection against domestic violence, paternity, modification, and temporary custody of minor by relative. Guardians ad litem are usually appointed in contested adoption matters, contested dissolutions of marriage, contested paternities, and contested modification matters. Although guardians ad litem can be appointed in injunctions for protection against domestic violence and temporary custody of minor by relative, it is rare that these appointments are ever ordered. A little bit about the cases before you. An adoption case is a case by which a child becomes, through a court action, the legal child of a family that is not the child's birth family. A dissolution of marriage is the term we use in Florida to talk about divorces. We also use an acronym when going through dissolutions of marriage. We use the PEACE acronym, P-E-A-C-E. P is for parenting issues because we don't use the phrases custody and visitation in the state of Florida when we're talking about the child of the parents. We use parental responsibility, which is the major decision making, time sharing, which is where the child spends their days and nights, and then we have it all in a document called a parenting plan, which we will talk about later in this training. Once we have discussed all of the parenting issues for P, we go to E, which is equitable distribution. That is the distribution of the marital assets and debts. A is alimony or spousal support. C is child support. And E is everything else. When a guardian ad litem is appointed in a dissolution of marriage case, that appointment is generally focused on P, the parenting issues. It can be a whole as to the guardian ad litem recommending parental responsibility and time sharing. It can be limited as to just parental responsibility or whether to waive a child's privilege. It can be limited to who's going to care for the child with special needs. It all depends on the scope of your appointment and what is in your court order, which will be talked about later in this program. Injunctions for protection against domestic violence are a mechanism to keep a victim from receiving further harm or further threats of harm. And an injunction for protection against domestic violence can be granted when there has been an act of violence or a threat of violence against the petitioner. Paternity is the P part of the dissolution of marriage, the parental responsibility, time sharing, and parenting plan, without the dissolution of marriage. Individuals who have children in common and they want to establish legal paternity or establish parental responsibility or a parenting plan or child support would file under this cause of action. Modifications can be filed for any of these causes of actions except for adoptions. You can file a modification in a dissolution of marriage, a paternity, an injunction for protection against domestic violence, and not necessarily a temporary custody of minor by relative case. But when requesting a modification of a matter, you have to prove there's been a substantial unanticipated material change in circumstances that is more than a temporary change. So we use the guidepost of 1 year, and that the request you're seeking from court in that modification portion is in the child's best interest. And as the guardian ad litem, you are all about the child's best interest. We are here to recommend what we feel is in the child's best interest. The temporary custody of minor by relative is usually a action that is held by consent or acquiescence. The only time a guardian ad litem is likely to be appointed is when it becomes contested. I've had cases where we have two sets of grandparents, both seeking temporary custody of the same minor, or I've had cases where the temporary custody order was close to expiration, or the parent became stable and came back in and wanted to regain their rights to their child, and then there was a discrepancy as to whether or not they were fit. And once a temporary custody case under Chapter 751 becomes contested, that goes more under a Chapter 39 standard, and a guardian ad litem would likely be appointed. In these cases, generally there are just two parties, the parent 1 and parent 2. When the guardian ad litem becomes appointed, the guardian ad litem becomes a party and must be copied on all pleadings and notified of all settlement negotiations and included in any court hearings. However, there can be more than two petitioners or more than two respondents, like I just discussed with the temporary custody of minors. It could be two parents versus a grandparent, or it can be, parent 1, parent 2, and then a business. I mean, there are a lot of different variations. And as you will learn, the more you practice in domestic relations court, the more variations there can be, because these are families. So everybody's family is unique. Their situations are unique. But generally, in your appointments, there will be two parents. Once the guardian ad litem is appointed, of course, you become a party until the date you receive your discharge order. The minor, unlike in dependency cases, the minor in domestic relations cases is not a party to the case, unless it's been a different type of case that was filed on behalf of the minor, like an emancipation action, or if it was a paternity action filed on behalf of a minor parent and the next of kin, or the parent, or someone else filed on that child's behalf. But no matter the type of case, if it's in domestic relations court and is not part of unified family court, there are different rules for whether or not a minor can participate in the court case. The courtroom. When you go to court as a guardian ad litem, there will be a multitude of people in the courtroom with you. You have the judge, the trial clerk, the court deputy, the petitioner, counsel for petitioner if available, the respondent, counsel for the respondent if available, guardian ad litem, and occasionally you as the guardian ad litem may choose to have your own counsel. And then you have your witnesses. Who is not in the courtroom? The minor child. Pursuant to Florida Family Law Rule of Procedure 12.407, minor children cannot be brought to the courtroom or participate in the court case without some other criteria being met. That is why you, as the guardian ad litem, are generally appointed. You're appointed to make the recommendation regarding what's in the child's best interest and to relay the child's preference to the court. Here is the rule. Florida Family Law Rule of Procedure 12.407. There are three parts to this rule, A, B, and C. A is the prohibition part, and as it reads, unless otherwise provided by law or another rule of procedure, children who are witnesses, potential witnesses, or related to a family law case are prohibited from being deposed or brought to a deposition, from being subpoenaed to appear at any family law proceeding, or from attending any family law proceeding without prior order of the court based on good cause shown. Here in Orange County, in our domestic violence injunction cases, the courts have a red stamp that they put on all the orders reminding parties not to bring the children to court. B, related proceedings. In a family law proceeding held concurrently with a proceeding governed by the Florida Rules of Juvenile Procedure, the Florida Rules of Juvenile Procedure govern as to the child's appearance. And as you know, those of you who've served as guardian ad litem in dependency court or as attorneys in dependency court, the child is a party to the proceeding and is entitled to be present at all hearings. The same goes for unified family court. If your domestic relations court is before a unified family court and there's an ongoing dependency case, then that child has the right to be present at that hearing. As the guardian ad litem, you can help make recommendations as to whether or not the child is too young to be present to the hearing or not of sufficient maturity to be present at the hearing, or make the recommendation for the child to be there and to speak. You are not necessarily advocating on behalf of anyone, but you do want to always make recommendations for the child's best interest. With the uncontested adoption, this rule does not apply. The child is allowed to come to court for an uncontested adoption. If you are not before a unified family court, a juvenile dependency proceeding, or an uncontested adoption, you have to file a motion and an order for testimony and attendance of a minor child at any hearing. And when I say you, I mean parents' counsel. The guardian ad litem can file motions. You may or may not have to retain counsel for that. It depends on your circuit. Most of our guardian ad litems are attorneys, and so they are able to file actions on their own. But that is a decision that's best left to you to determine for your practice. There are Florida Supreme Court forms available to you if you would like to file a motion for testimony and attendance of a minor child, or if you would like to do your proposed order for testimony and attendance of the minor child. Those forms can be found on the Florida Supreme Court website at flcourts.org, and then by clicking self-help and family law forms, or just by going by family law forms. I have placed the link in this presentation to show you how to go directly to the forms site. If you use your own forms, I always recommend that you use the Florida Supreme Court forms as your backbone to make sure that you're not missing any of the necessary language to get the relief that you are seeking. The stages of domestic relations court. You have the initial pleading stage, which would be the petition, and that would be for dissolution of marriage, paternity, or any of the other proceedings. You have an answer and a counter petition, an answer to the counter petition. And in Florida, if there is a case pending and there are children involved in a case, a domestic relations case, the parties have to complete a parenting class within 45 days. The petitioner has to do it within 45 days of filing the action. The respondent has to complete the class within 45 days of being served with the action. There's also the same requirement for mandatory financial disclosure. Then you have an investigative phase or a discovery phase, which could include interrogatories, requests to produce, subpoenas, depositions, and requests for admissions. There's also an opportunity to have at least 2 mediations. You can have a temporary mediation to have temporary relief, or you can have your final mediation to come to a full resolution of the matter or prepare for trial. If you have a full agreement, then you can go directly to a final hearing, provided the parenting class has been completed, the financial affidavits have been filed, and you have completed your circuit's checklist for all things needed for the final hearing. If there has not been a full agreement on all the matters, then a trial will need to be held. Now, as the guardian ad litem, you will normally be involved in the trial or the mediation, and some of the discovery. But it depends as to when you are appointed to the case and what issues are contested. When is the guardian ad litem appointed to the case? It varies. You could be appointed in the very beginning. I've had some cases where, contemporaneously with the petition, a motion for appointment of guardian ad litem is being filed. Or some cases where they wait until, mediation and then determine that they're not going to be able to reach an agreement and request a guardian ad litem. Or sometimes there are some issues that are just so specific that the parties cannot agree as to what school the children would go to, or relocation, whether or not the child should be permitted to relocate, that the guardian ad litem is appointed, in the midst of the litigation. Once you are appointed, remember to review the proposed appointment order, have a retainer meeting with the parties, notify the parties' attorneys and send them any questionnaires that you would like the parties to complete, and file your acceptance or accept your order of appointment. Why is the guardian ad litem appointed? Florida Statute 61.401 deals with the appointment of guardians ad litem. In an action for dissolution of marriage, or for the creation, approval, or modification of a parenting plan, if the court finds it is in the best interest of the child, the court may appoint a guardian ad litem to act as next friend of the child, investigator, or evaluator, but not as an attorney or advocate. Remember, there is a difference between a guardian ad litem, which is a child's best interest attorney, and an attorney ad litem, which is an attorney for the child. A guardian ad litem cannot be both a guardian ad litem and an attorney ad litem for the child at the same time. However, you can serve as a guardian ad litem first and then an attorney ad litem, or vice versa, if you saw that that was in the child's best interest. There is a mechanism for that. However, that is not common. Since you are tasked with making recommendations for the parenting plan, let's talk a little bit about the parenting plan requirements. Pursuant to Florida Statute 6113-2B, a parenting plan approved by the court must at a minimum describe in adequate detail how the parents will share and be responsible for the daily tasks associated with the upbringing of the child. Remember, there are different types of decision making when it comes to the daily task associated with the child. You have the major decision making, which is the parental responsibility, and then you have the day-to-day decisions. And the day-to-day decisions are normally made by the child the parent is with at the time. But as part of your recommendation, you're going to recommend who gets to make the major decisions. Will it be shared parental responsibility, where the parties meet and confer about any major issues regarding the child, and then come to a mutual agreement? And these major issues can be things like, the school selection, other issues with the child's education, health care, and anything else that may be unique to the family. Also includes the mental health portion and who's making decisions. Another type of decision making would be shared parental responsibility with decision making authority. That is when the parents do their best to confer about an issue. But if they cannot make a mutual agreement, then one parent gets to make the ultimate decision. And normally, when we have ultimate decision-making authority, we specify that it can be for academic or educational issues, or non-emergency health care, and things of the like. If you have a situation where it's detrimental to the child for the parents to share in the major decision making, then you would want to recommend sole parental responsibility. That is where one parent makes the major decisions for the child and, if possible, informs the other parents of those decisions. Some instances where sole parental responsibility would be granted is where the whereabouts of the co-parent are unknown, or where there is a significant history of domestic violence and the parties are not able to communicate. If the parties can't communicate, they can't reach a mutual decision. A second requirement for the parenting plan is that it includes a time-sharing schedule, arrangements to specify when the minor child will be with each parent at any given day, 365 days a year. This is normally done by getting a copy of the child's school schedule. And if they're not in school, I still suggest you use the school calendar as a way to plot out the different days the child will spend with each parent. Because your parenting plan is going to talk about any school breaks, what a definition of a school break is, and that's going to be important to you when you're talking about spring break, summer break, Christmas break, fall break, winter break, whatever break you have in your school district. Your time sharing schedule is going to talk about weekday and weekend schedules. It can be highly detailed where it specifies the date and time of all pickups and drop-offs, or you can just say the days and use after school or before school. Since I do a lot with domestic violence victims, I always ask for specificity in the schedules so that it takes away some of that power and control the batterer may have over my client who's a victim. In dealing with the schedule, in addition to the weekday and weekend times, you're also going to talk about holidays, school breaks, like I said, the winter break, spring break, summer break, and my situation in my district, sometimes we have a fall break. It's going to also take into account whether or not there are going to be any third-party exchanges for the child, or how the child will be exchanged, whether there are any transportation issues for the child, who's going to do the pickup and drop off, and if there are any transportation costs or foreign and out-of-state travel. For instance, if you have parents who live more than 50 miles away from each other, then there may be a lot of transportation costs associated with their parenting plan. You're not expected to investigate the cost. You're expected to make a recommendation as to whether or not this would be in the best interest of the child. In your parenting plan, when we talked about parental responsibility, there are places where you have to actually designate that for all other legal purposes, the parenting plan would be considered somewhat of a custody order. Even though we don't use the phrases custody in Florida, when showing this court order to the school, for example, they don't all use the same terminology. And to just say it's a custody order for some individuals, or if you're leaving the state, may be easier. So there's a designation for legal purposes in the parenting plan that says, this can be determined a custody order for school boundary determination. The parenting plan also has to talk about who's going to be responsible for all forms of health care. And if you're not using the Florida Supreme Court form, be sure that you include the statutory requirement that says if the court orders shared parental responsibility over health care, the parenting plan must provide that either parent may consent to mental health treatment for the child. Also, your parenting plan will designate who's responsible for other activities. There's a portion there that talks about extracurricular activities, whether or not the parties are going to mutually agree upon those activities, or, just sign the child up for whatever activity they think is best, as long as it doesn't encroach upon the other person's time sharing. As a guardian ad litem, you will get a feel for the parties and how they interact as a family unit, and whether or not they are able to responsibly sign the child up for activities, or whether they would be, uncooperative in situations of that. The parenting plan also must describe in adequate detail the methods and technologies that the parents will use to communicate with the child. Will there be open and liberal or reasonable visitation by telephone, email, or any other electronic means? Who's going to be responsible for the cost of those electronic means? How is the communication going to occur between the parents? Are they going to communicate by telephone, email, third-party communication tools like Talking Parents or Our Family Wizard? All of these are things that are going to go into the parenting plan. What type of parenting plans are there? You can have a mediated parenting plan where the parties went to mediation and reached a full agreement with the guardian ad litem's input. If they go to court or they go to mediation, and I'm talking about the parents and their counsel, without including the guardian ad litem, the guardian ad litem still has a say as to whether or not that mediated agreement is in the child's best interest. Same thing with the marital settlement agreement. If the parties reach a marital settlement agreement or paternity settlement agreement and did not include the guardian ad litem's input on the parenting issues, you still have a say in that until the day you are discharged. Even after you have submitted a written report, you still have a say in what you recommend as the child's best interest. And if there is a contested hearing or the judge crafts the court-ordered parenting plan, you should have been present at that hearing and had input in those recommendations. If a hearing was coordinated without your knowledge or occurred without your knowledge, you may want to notify the courts or the parties as soon as possible so that you can provide input as to a recommendation regarding the best interests of the children. There are 3 Florida Supreme Court approved family law parenting plans, and they are located on the Florida Supreme Court website at the link I provided earlier, www.flcourts.org, which is flcourts.org, under family law or self-help, and then in the parenting plan forms. All of the information that I just discussed would go into the regular parenting plan, which is form 12.995A. If for some reason there needs to be a restriction on the type of time sharing that's available, then the supervised or safety-focused parenting plan may be a better choice. That is form 12.995B. In that plan, when it comes to time sharing, it talks about the options of no time sharing with the other parent, because any time sharing would be detrimental to the child, or sole parental responsibility and no decision making to the other parent. There are options for supervised time sharing or restricted time sharing. In form 12.995, the long distance parenting plan, that form is pretty much the same as the basic form, except for when you get to the transportation and exchange of the children section. It goes into greater detail with automobile transportation and exchange, airplane and other public transportation and exchange, and the cost of any airline and other public transportation. And again, remember, the long distance parenting plan is for when the parents live more than 50 miles away from each other. What type of court events are there? You've heard me discuss mediation, and mediation is a settlement conference between the parties. Everything that is said in mediation is confidential and cannot be used as a discovery or an investigation tool, with the caveat of any ongoing crimes or abuse to children or elderly. Because remember, in the state of Florida, everybody over the age of 18 is a mandated reporter for child abuse. Everybody has to report if they see abuse occurring with children or the elderly. Another type of court event is a deposition, which is a question and answer session before a court reporter under oath outside of court. And children sometimes are subpoenaed to depositions, or the parents are deposed, or the witnesses are deposed, or the guardian ad litem is deposed. As a guardian ad litem, you have the opportunity to be involved in the deposition of the parents or the witnesses when it comes to asking questions. Some guardian ad litems get their own attorneys to represent them or their interests at the depositions or the hearings. And there are different types of hearings. There are ex parte hearings, which are hearings that are provided without notice to the other side. And they could be, routine hearings or emergency hearings. There are short motion hearings. And in my circuit, that's what we call them, short motions or short matters. These are hearings that are less than 15 minutes long that don't require any testimony or evidence. These are attorneys arguing over discovery or basic matters. You have temporary relief hearings where you're going in for temporary time sharing and other matters. Emergency hearings such as, domestic violence injunction hearings or emergency child pickup hearings where the party has taken the child and refused to return the child. You have emergency relocation hearings where someone is relocated in violation of Florida's relocation law, and one parent is requesting that they be immediately brought back. There's also an emergency where the child is on the way to the airport to get on a plane with a parent to fly to a country that's not a signatory to the Hague Convention. Those are some examples of the different types of emergencies that you may face in domestic relations court. Whether or not somebody came back from a pickup, 15 minutes late, or whether they, brought their girlfriend with them to a pickup, or whether, someone is missing time sharing for a day is not considered to be an emergency. It may be an emergency to the parties, and it may feel like an emergency to the child. But for most courts, it doesn't reach the burden of emergencies. Emergencies are something where if the court doesn't correct it right now, there may be irreparable harm. And then our courts always tell you if you feel the child is being abused, abandoned, or neglected, to report it to the Department of Children and Families Abuse Hotline at 1-800-96-ABUSE. The other type of motion hearings we have are evidentiary hearings, which could be set for 5 minutes or 5 hours, depending on the issues to be litigated. And those require advance notice, and there may or may not be discovery associated with that. And again, if the hearing is related to any time sharing matters or any parenting issues, you want to be present. If the hearing is just solely on equitable distribution or something not related to the children, the marital home, even though that's equitable distribution, that's related to the children. But if they're arguing about a bank account in the Caymans, then that may not be the type of hearing that you want to be present at, and you want to make sure to be excused. Then you have the final hearing or trial. And in preparing for the final hearing or trial, remember you have to have filed your report and recommendations at least 20 days prior to the hearing. and then you would be permitted to testify also at the hearing regarding your recommendations. If the parties have already reached a full agreement with your input, then that would be an uncontested final hearing. If the parties have not come to a full agreement, then it would be a trial before the judge or a magistrate. How does the guardian ad litem participate in the proceedings? Once you are appointed as the guardian ad litem, you should review the court file and any companion court files. You may have to get permission from the court to review any confidential court files such as mental health records, Baker Act records, or things of that nature. If you are aware that those such files exist, then determine whether or not it would be in the child's best interest for you to review those files. You should also speak with the parties and any collateral witnesses. Get the contact information for the collateral witnesses when speaking with the parties, not just their address and email, but also their phone number, because you want to make sure that you're going to get all that you can get from them. Also, when the parties give you the name of any witness, ask that party what that witness can testify to, because you don't want to spend a lot of time and resources interviewing cumulative witnesses. You also want to review education and medical records. As a party, you should be participating in any settlement negotiations, whether formal and informal. If they're going to have a conference call, then you want to be on that conference call if they're talking about parenting issues. And then attend all hearings regarding the minor children. Hearsay. Florida Statute 61.4035 states that the guardian ad litem may address the court and make written or oral recommendations to the court. The guardian ad litem shall file a written report which may include recommendations and a statement of the wishes of the child. So Florida Statute 61.4035 directly tasks you with reporting on child hearsay. Hearsay is a statement, whether oral, written, or nonverbal conduct of a person, made outside of court and then offered in court to prove the truth of the statement, the truth of the matter asserted. The dilemma we face as guardians ad litem in domestic relations court is that our reports and testimony are significantly based on hearsay, and as you see in the statute, we're statutorily required to report on child hearsay. But neither Florida Statute 61.403 nor the Florida Evidence Code waive the hearsay exception for the guardian ad litem. And there is our dilemma. The court held in Scaringe v. Herrick that when a guardian attempts to testify to hearsay statements and a valid hearsay objection is raised, that objection should be sustained. Thus, great portions of the GAL's report and testimony could be excluded based on valid hearsay objections. Our proposed solution to the problem? Obtain hearsay waivers up front. Get those waivers in both the order of appointment and the retainer agreement. In your appointment order, you should determine whether to use a limited hearsay waiver or a blanket hearsay waiver. In the following slides, we'll discuss a few examples of the waiver language. Here is an example of a limited waiver. The parties and their respective counsel agree to waive hearsay objections regarding a guardian ad litem's testimony and written reports only as it pertains to A. School personnel, included but not limited to teachers, guidance counselors, and principals. B. The children's healthcare professionals, included but not limited to pediatricians and treating medical professionals, but specifically excluding the children's therapists. And C, the children's statements. Hearsay objections to all other individuals are preserved. I have two reminders for you regarding the waiver language. The parties can always agree to waive hearsay regarding the recommendation and reports, but retain their right to cross-examine the guardian ad litem. Additionally, the parents cannot waive the psychologist-patient privilege of the minor child when the parents have a personal interest in that waiver. And that is why there's the exclusion of the child's therapist when it comes to the waiver language. On occasion, the guardian ad litem will be appointed specifically to determine whether or not to waive that child's privilege. In addition to having the retainer agreement signed and a limited waiver, try to also get signed releases from the parents so that you can access different records. Remind the parents and the parties that whenever they're speaking to you, nothing they tell you is off the record, because you're not their attorney, you're not the child's attorney, and you're not advocating for anyone. You are gathering information to make your report and recommendation. I prefer a blanket waiver, and here is the sample language for a blanket waiver. It references Florida Family Law Rules of Procedure 12.407. Remember, that is the rule that deals with the minor child testimony and attendance. It also references providing addresses for parties. Remember, if you're dealing with a situation of domestic violence or for some other reason that the parties or the witnesses have confidential addresses, you are tasked with keeping that address confidential. You can still make the name known, but there will be other mechanisms put in place to provide counsel for the parents an opportunity to question that witness. That being said, this is what my proposed detailed blanket waiver is. And I've gotten this over the years through so many other trainings that I have attended. The parties to this action shall agree prior to hearing that there shall be no hearsay objection to the content of the guardian ad litem's report, and in the event such an objection is to be raised, the objecting party shall subpoena the witness from whom they object to the hearsay evidence, subject to Florida Family Law Rule of Procedure 12.407. The guardian ad litem shall list the names and addresses of the persons interviewed whose statements they have repeated or summarized in the report. And if the addresses are not provided, the hearsay testimony is subject to hearsay objection. For your retainer agreement, determine whether or not to use a hearsay waiver. It is strongly suggested that you do, even if that waiver is solely for the limited purpose of using child hearsay. When determining what to include in your hearsay waiver, determine whether to limit it to the child, school personnel, and healthcare professionals, or whether to have a blanket waiver. Here is sample language for the retainer agreement. You agree that you will not object to my report or my testimony being admissible in court because it contains hearsay as related to the child and statements by the child to me. You acknowledge that I have been asked to serve as a guardian ad litem for the purpose of investigating issues involving your child, and that is in your child's best interest to permit my report and testimony to be introduced into evidence despite the fact that it may contain hearsay. This is the clause that I would use in my retainer agreement because at the very least it addresses the statutory task that I've been given. You can choose whether or not to use a more broad waiver in your retainer agreement, but remember to discuss your waiver with the counsel for the parties. I would make sure that the waiver in your agreement, if it's going to be broader than this, mirrors the waiver in your order of appointment. Special considerations. When investigating what's in the best interest of the child, please remember to keep an eye out for indications or allegations of domestic violence, substance abuse, mental health, or estrangement and alienation. In the last few minutes of this portion, we will focus on domestic violence and the parents using the children as a form of abuse. And before we end this segment, I'd like to spend more time on domestic violence. What we have in front of you is the power and control wheel. The power and control wheel can be found at the website on the bottom of your screen, www.theduluthmodel.org/wheels. This wheel is used in almost all domestic violence cases because domestic violence is more about power and control than it is about physical violence. And domestic violence doesn't have to be physical in order to meet the definition. It could be physical, it could be sexual, it could also be emotional. And on this wheel, we're going to discuss some of the different types of power and control that could be used in the relationship. Using intimidation. Making her afraid by using looks, actions, or gestures. Sometimes your clients will say, or the parents will say, well, he gives me that look. Or even the children would say, you know, he gives me that look. Or a side eye, or whatever. Using emotional abuse, putting her down, making her feel bad, calling her names, making her think she's crazy. Using coercion and threats. Making and or carrying out threats. You'll never see the children again. If I can't have you, nobody will. Or I'll kill you and myself. Things of those nature. Or you may see there have been a history of domestic violence injunctions filed, but they've all been dismissed. Or there may have been arrests, but the charges have been dropped. And it could have been the abuser coerced or threatened the victim into dropping those charges. And when we go through these wheels, we're going to use the female as the victim and the male as the abuser. But in reality, it can go either way. Another form of power and control is using economic abuse, preventing her from getting a job and keeping her job, making her ask for money. You may have a situation where the batterer calls the job multiple times. And if she doesn't answer, he calls the boss or he comes down to the place of employment, which almost always leads to her losing her job or giving her allowance or taking whatever money she does make from the job, or not allowing her any access to the family income. The power and control wheel also shows a use of isolation, controlling what she does, who she sees and talks to. We have a lot of them where the batterer won't allow the victim to go to school, or won't allow the victim to get a job, or won't allow the victim to talk to her friends or her family. Limits the amount of activity she has outside of the house, and uses jealousy as one of the reasons for it. Minimizing, denying, and blaming, making light of the abuse and not taking her concerns seriously. Oh, I just slapped you once. or I didn't mean to hit you that hard, or you fell running from me, I didn't push you down. Sometimes they'll say the abuse didn't happen. Sometimes they'll shift responsibility from the batterer to the victim. Well, you made me do it. Or saying that she caused the abuse. Using the children. And there's another will that I will talk about after this one that talks about using the children. In this will, using the children to make her feel guilty, using the children to relay messages, using visitation as a means of harassment, or threatening to take the children away. When it comes to making her feel guilty about the children, if it weren't for you, both of us would be living together and I can see my kids every day, or my kids could see me. Or using the children to say, you owe mom money, or you owe dad money, or dad says that you're dumb, or dad says that your boyfriend is a pig, situations like that. Or using visitation as a means to harass. He'll, if there's not a detailed time sharing schedule, which is what I always recommend, the batterer will show up at all hours of the day or night claiming they're there to see their child, when really they're there to harass the victim. Or they may pick the child up late in order to make the victim late for work or for school, or pick the child up early and cause a commotion if the child's not ready. So be mindful if there are a lot of issues occurring during the time sharing exchanges. It could be an indication of something deeper. And then using male privilege, treating her like she's a servant. He makes all the decisions. He acts like the master of the house, or he's the one defining who does what in the family. Using the children as a form of power and control. In situations where there is an abusive relationship, going through this post-separation power and control will can assist you in preparing your parenting plan recommendations. For instance, if in the relationship the batterer uses harassment and intimidation by threatening to destroy things belonging to or related to the children, or using the children to justify breaking the injunction, or threatening and stalking the victim and the children, making his presence known when he shouldn't be, abusing their animals, or using third parties, you would see that and would recommend a supervised, safety-focused parenting plan, restricting the amount of time he would have to the children and the access he would have to the children's belongings. If the parent undermines the other parent, that goes into parental responsibility. You have the day-to-day decision makings, but parental responsibility, if they're disrupting the child's sleep and feeding patterns. This is why in the parenting plan, when it comes to time sharing and communication between the parent and the child, I always recommend a set schedule, that it be, between a 30-minute to an hour time frame, no more than 2 times a week, where the batterer can call the children. That way the batterer's not calling 24 hours a day, 7 days a week. I had one case where bedtime was 9 o'clock. Dad called at 8:59 every single time, and the children could never go down before 10. Or the situation where bedtime is at 9 and dad calls at midnight demanding to speak to the children, or threatening to hold the mom in contempt for not putting the children on the phone. For these reasons and many more, when it comes to issues of domestic violence, it is strongly suggested that you have as much details, or as many details as possible, in the parenting plan. For the undermining her as a parent, it also goes into withholding information about the children's social, emotional, and physical needs, contradicting her rules for the children, and demanding visitation schedules at the children's expense. I don't care that this child has a football playoff today. It's my day and he needs to come. I don't care that this child has a doctor's appointment tomorrow. I'm not taking her. So you need to reset everything on your day. Those are some things to keep an eye out for, as well as whether or not they're going to be delegating their duties to a third party. Using physical and sexual violence against the mother and the children, threatening to kill or kidnap the children, physically hurting her or abusing the children, threatening suicide, forcing sex, or exposing the children to pornography are all different types of abuse and different ways to use the children against the parent. If you have a case where the children do not have passports and there is a concern that they may be taken out of the country, remember you can always recommend that the parents enroll the children in the Children's Passport Issuance Alert Program through the Department of State. And that will alert the parties anytime a passport application is applied for in the children's names. Another form of post-separation power and control is disrupting her relationships with the children. That would be the estrangement or the parental alienation, coercing the children to pick one parent or saying that you don't love me if you pick the other parent. It would be degrading her to the children, using the children as spies. I have situations where the children come back from time sharing and the parent inquires as to what they did every moment they were away, who they saw, who came into the parent's house, so on and so forth. So keep an eye out for that as well. And you can also tell too if the parents are involving the child in the litigation, reading the pleadings to the children, or insisting that the children come to court to hear what the other parent has to say. Discrediting her as a mother, using her social status against her, her sexual identity, immigration, race, religion, education, income, inundating systems with false accusations of bad parenting. You may get cases where, the father repeatedly calls in DCF reports and they're all closed as unfounded, but DCF is coming out to the home and inconveniencing the parties and scaring the client. You may have cases where the father insists on doing well child checks and consistently send the police over to the mother's home to check on the children, or use them as a way to gain her address if she has a confidential address or if she has gone to a safe place away from him. You also may have them say, well, I can get the kids because if not, I'll get you deported. You may also have the family members, the in-laws, threatening to have the parent deported. Those are some things to keep an eye out for. Withholding financial support, not paying for any of the children's medical expenses or any of their field trips or school supplies, not paying child support or health insurance when they're well able to do so. That may be a form of abuse. Endangering the children by neglecting them or not watching them properly when they're with them, putting them in age inappropriate emotional and physical situations, or using violence in front of the children. Then you have disregarding the children, completely ignoring their school schedules or homework. They may have truant children. The children may not have any assignments turned in. Ridiculing the children's needs, wants, fears, and identities. Forcing the family members, new girlfriends or wives, and other women to do all of the parenting work, or treating them as younger or older than they actually are, or strictly enforcing their gender roles. These are some things to keep an eye out for when evaluating what is in the best interest of the children. If you have any questions about this presentation, please feel free to reach out to me by email at tchall@legalaidocba.org or by phone at 407-841-8310. Thank you for spending this time with me today, and I hope that you found this to be very helpful.
My name is Jessica Thomas, and I am an attorney here in Central Florida, where I own and operate the Thomas Law Firm. I practice in the areas of family law. I also do adoptions, dependency, and guardian ad litem work. I've been an attorney for almost a decade now, And a big chunk of that journey has been dedicated to being a guardian ad litem. In fact, I have been doing guardian ad litem work almost exactly when I started practicing back in 2011 with the Legal Aid Society of Orange County. It was such a different perspective to see a case through solely what was in the best interest of the minor children, that I believe it truly helped me to be a more fierce and zealous advocate as a litigator, to be able to come out of my position and truly see what was going to help this family in the long run. In addition to being a guardian ad litem, I had been a mediator for several years until I was appointed by the Florida Supreme Court to our Mediators Qualification and Discipline Review Board for the state of Florida to help assist with the rules and governing procedures for our mediators in the state of Florida. I give you this background to know that today, as I assist in training you on becoming a guardian ad litem, I want you to understand the benefit to doing this not only in a private capacity in domestic matters, but I encourage you to seek out your local legal aid society and assist on a pro bono capacity. The insight and the impact that you will receive from being a guardian ad litem is immeasurable. And I encourage you to take that journey after you watch our video today and feel confident that you have the rules and the tools to move forward in doing your very best for the children subject to any action. I do want to make a point to outline that everything that I'm showing you today is available in our materials, and I made a point to have everything here for you to even see what's available for you online, and I'll try to give you some tips and tools and insights as we go through our training today. Lastly, when in 2018, I was awarded the Elizabeth Susan Corey Guardian Ad Litem of Excellence Award. And receiving that award of excellence truly gave me great joy and great inspiration, because we all are recognized for being fierce litigators and, prevailing in one different legal matter or another, but to be recognized for being a guardian ad litem and how many hours and how much dedication we put in to ensuring that we are truly looking out for what's in the best interest of the child was a undescribable feeling. So with that, and now that you know a little bit about me and why I'm here today to assist you in becoming a guardian ad litem, let's delve in. First and foremost, we are going to talk about the statutes, and I have everything here for you. You can follow along, you can, have your phone, and I think this will help you understand what your role is as a guardian ad litem and what is a guardian ad litem. So the first statute that we have is Florida Statute 61.401, and this is about the appointment of a guardian ad litem. So when you appoint someone as a guardian ad litem, you are in an action for dissolution of marriage or approval or modification of a parenting plan, which we know as practitioners, those can be paternity cases. The court may appoint a guardian ad litem to act as the next friend of the child, investigator, or evaluator, not as an attorney or an advocate. Let me stop there just for a moment. There are things called attorney ad litems, which you will learn more about in this presentation from one of our other esteemed presenters. But in your role as a guardian ad litem, you are not advocating for win or lose, relocate or don't relocate, mom or dad. You are relaying to the court what you have found is in the best interest of the children based on the context of the facts and the documents and the interviews that you have taken in conducting your report. So it's important to remember that. It's difficult, I think, for some litigators to cut that off and to say, okay, I'm not, going to say that I definitely think mom is right or dad is right. That's not your job. Your job is to be there to say, this is what the children will need. This is what school I believe is best for them based on reviewing copious amounts of evidence. So that's first and foremost Florida Statute 61.401. And to notate that the court in its discretion may appoint legal counsel for a child, that's the attorney at litem. However, the guardian and the legal counsel shall not be the same person. In such actions which involve allegation of child abuse, abandonment, neglect, that's Chapter 39, everybody knows dependency, in which an allegation is verified and determined by the court to be well-founded, here's the point, the court shall, hear me, shall. Now, we all know the difference. The may, you're doing a motion, right? You're doing a motion, you're saying, Your Honor, I'm asking you to do this. In dependency court, guardian ad litems shall be appointed. When we're dealing with abuse, abandonment, or neglect, there has to be a voice for that child, period. End of the sentence. So this is important for you to know the distinction between a domestic case and a dependency case to understand that in one, you're seeking the insight of somebody else. In the other, it is a requirement that that person is available to speak on behalf of the children. Now, I want to go just a smidge out of order and go ahead and show you that we have the motion for appointment of a guardian ad litem. That's going to be Florida Supreme Court Form 12.942A. Now, of course, most of us as practitioners, we draft our own forms, but I wanted you to know that this was available. When I was a baby lawyer, you don't always have the benefit of mentorship. You don't always have the benefit of someone that you can say, hey, I don't understand this. Can you help me? So the Florida Supreme Court is a really good skeleton that you can build on and put your own meat. In a motion for appointment of guardian ad litem, you're talking about, of course, what children are subject to the action. You're talking about whether there's been any Chapter 39 allegations, because that's letting the judge know I must appoint or I may. I shall or I may. Then you're letting the court know what issues you're being asked to review. Are you dealing about parental responsibility? Are you looking at a time sharing schedule? I want to point out to you that guardian ad litems get appointed in all types of cases, but we'll get to that later. I don't want to give you too much, but when this other line, I have seen guardian ad litems rule on drug testing and whether or not they thought the drug testing should be done in front of the children. I have seen guardian ad litems rule on disbursements of funds. I have seen guardian ad litems rule on, whether or not they believe that this child should be able to participate in a certain activity. We always think very grandiose as if it's got to be parental responsibility or time sharing. That's it. That's what guardian ad litems decide on. But that's not it. I want you to open your mind and say, if you guys are truly looking at something that's going to benefit the children and you're at an impasse between the two of you, you need somebody else, a neutral third party, to review the facts and make a recommendation. You also have to, of course, outline how this motion is in the best interest of the children. We'll get to that. That's Florida Statute 6113 about the best interest factors. And then, of course, just your certificate of service. Okay. So that's important for you to know as far as a motion to appoint a guardian ad litem and how within the statute you're able to move forward with your appointment, whether it be in a domestic case or dependency matter. Up next, then we have the key point of qualifications of a guardian ad litem. Now that's coming from Florida Statute 61.402. If you're following along, of course, this is for CLE credit, so I want you to truly be absorbing what we're talking about, and it's beneficial if you see the same thing as me, because I'm not reading the whole statute verbatim for you. I know that you guys are all practitioners and can review it yourself, so I'm just kind of highlighting the big points. Now, in the qualifications for a guardian ad litem, we have that you need to be certified by a guardian ad litem program. That's pursuant to 39.281, that you're certified by a not-for-profit legal aid organization, which is 68.096, or you're an attorney who is a member of good standing for the Florida Bar. And I understand that this training is for the entire state. So whether you're in Dade County, Alachua County, Bay County, Leon County, the benefit of being a legal practitioner is boom, there you are. Letter C, that's it. But I implore you, and you're already doing it today, so I guess I don't need to implore you, but I implore you to go to those trainings that your local legal aid society is offering. It has been beneficial. They help you with cases where you're a guardian ad litem and there's a child with special needs. They help you about reviewing IEP plans and 504s and understanding what children's education concerns need to be. They talk about medication prescribing. Our Orange County Legal Aid Society puts on these amazing lunch and learns. And I will tell you that it has been beneficial not only as a guardian ad litem, but again, the crossover as a practitioner and a guardian ad litem is just day in and day out valued and apparent when you're going to these trainings. So although you're not required to be certified, although that's accurate, I really encourage you to do that. And that's part of why you're here today. You have decided that I'm an attorney. I could go to any case I want right now. Don't even need to do anything, but you want to know more. You want to say, I did this statewide training. I know these statutes. I know these forms. I've seen the reports. I know what I'm supposed to do. And so I applaud you for that. Okay, so now that we know who qualifies as a guardian ad litem, prior to certifying a guardian ad litem pursuant to the not-for-profit legal organization, there must be a certain amount of things done, like background checks, things like that. They already have that here. They talk about that the only person who has qualified under a guardian ad litem as a guardian ad litem can be appointed, and that it's, of course, a misdemeanor if you misrepresent that you know any of this or that you're a practitioner, which we know. That we know. So I want to, again, go back to the forms for you. This is Florida Supreme Court Form 12.942B, and this is the order appointing guardian ad litem. Now, here's where some practice tips come in. I will tell you that I have seen some phenomenal orders, and this order is important. Now, this is the Florida Supreme Court form, but I want you to know about the phenomenal ones. The phenomenal ones are just like any court order that we as practitioners know. You need to anticipate what's going to happen. You're going to walk into a school and you're going to say, I need to speak with Susie Cakes Johnson, this teacher for little Bobby. Okay. Well, what allows you to talk to Susie Cakes Johnson? Oh, well, I have my order appointing me as guardian ad litem. Well, does it say you can talk to the teachers? Does it say that you can review little Bobby's records? Does it say you can make a copy? I know that sounds silly, but I'm being honest with you. The schools, the doctor's offices, everyone that you're going to need to interview, talk to, get the records from, they want to know that they're protected, that they're not exposing themselves to some kind of liability of allowing you access to these things. So it is important that your order is specific. Now, I say for you to start with the Florida Supreme Court order because it clearly outlines back here, what you're allowed to do, what documents you're supposed to be provided, that you're allowed to investigate the allegations, that you can maintain any information, that the parties have trusted you with giving you this information. It goes over each aspect of what you're permitted to obtain. You need to be clear about your role as a guardian ad litem, and this is going to tell you what you can and can't have access to, who you can and can't talk to, who you have to tell what you found or what, and we're going to get to confidentiality in a second. But it's important that this order is detailed, expansive, because you don't want to run into a roadblock. You don't want to, you don't know what's going to happen until you start doing the interviews, until you start doing the home visits, until you start reading these documents. I will give you an example that in a guardian ad litem case I had, there was an issue with one of the witnesses that did not speak English. And so I needed a translator, but I was concerned about whether or not I had the ability to just get my own translator, whether or not I had to tell them I was going to use a translator for this other interview. I had to be concerned about the cost of the translator. There were something that you just wouldn't think of, like something as basic as, I needed to talk to this witness. If there had been some very good specifics of what I'm supposed to do for outside costs, sometimes that comes up. What happens when you go to the criminal records and you want to print this whole file, something like that, and they say, oh, that's going to be 10 cents a page. Are you supposed to pay for that and then invoice it? Do the clients need to provide you with the documents? How long do they have to provide you with the documents? Do you have to give a copy to the opposing counsel? Do you give a copy to the person who hired you? What am I supposed to do? This is the order. Read the order. Details, details. Ask other guardian ad litems, hey, what have you found has been an issue? So you can be sure that you're addressing it in your order appointing, that you're making sure that you have a clear understanding, okay? The last thing, of course, that's in here is that it does have automatic, in the Florida Supreme Court form, the guardian ad litem is automatically discharged without further order of the court for 30 days after a final judgment on this proceeding. You want to be sure to check that out. The reason I say that is because what can happen is you can get automatically discharged. Someone does a motion to set aside, not a motion for, not an appeal within those 30 days, but a motion to set aside. They got to reappoint you and go through the whole process. So just think about those kind of hiccups that can come. Also, and again, we're going to get to this, you got to talk about what you're going to do for hearsay. Now, in the order, and this is a dice roller, as we know as practitioners, I don't know what the guardian ad litem is going to say. So if I put that we are waiving hearsay for this report, if I put as the practitioner that this report is automatically going to be introduced into evidence, any party can rely upon there, if I'm going to put that type of language, what if it's not in my favor? And now I'm stuck with this report. You really need to think about, as a practitioner, what's going to be in the best interest of your client. Now, as the guardian ad litem, I, of course, I want everything waived. I want my report in because I want the court to hear from me. Now, they can call you as a witness, of course, but you want this detailed report that you've made that's, 10, 20, 50 pages long. You want it to have some weight and credibility, the detail. You want to be able to have that available for the parties and for the court. But that's something that needs to be addressed, or you're going to be in a position where, as a practitioner, you've done all this work, your client has paid this money, and then they're not able to utilize what they have. Okay, I want to make sure I'm staying on time. Okay, next, we are going to talk about Florida Statute 61.403. This goes over the guardian ad litem's powers and authority. Again, I'm not reading things to you guys. We only have 50 minutes today. You are intelligent practitioners, intelligent community members. I know that you will read through this. It's important. Again, I'm giving you the highlights. Some of the highlights are that the guardian ad litem may assist the court in obtaining impartial expert examinations. This is important, as we all know, for child support to go past the age of majority. Let's say we're getting a special needs designation, and I need an expert that's going to show that this child's going to be dependent for, the foreseeable future. I, as the guardian ad litem, may say, hey, this is who I think is going to be able to give us that determination, that then I can say who's going to be better equipped to handle whatever this expert recommendations are. I'll be able to say, I think Susie Cakes Johnson, Dr. Susie Cakes, is going to be able to tell us who and what we need to be considering for little Bobby or little Susie in their special needs designation. That's a good one to recognize. Also here, the guardian ad litem through counsel. Now, this is important, and I've run into this before early on in my career. There was questions about whether or not the guardian ad litem needed their own attorney. Pursuant to the statute, they do. It says the guardian ad litem through counsel, clear as day, we're in section 2, may petition the court for an order directed to a specified person, agency, or organization, including but not limited to hospitals, medical doctors, dentists, psychologists, and psychiatrists, which order directs the guardian ad litem be allowed to inspect and copy, there goes that order, any records and documents which relate to the minor child or to the child's parents or other custodial persons or household members with whom the child resides. Such order shall be obtained only after notice to all parties and a hearing thereon. So the guardian ad litem, remember what it said. That's why we're going in this order. You're not an advocate. You're not supposed to sit there in a role and say, this is why I want to talk to this hospital today. That's not it. You need somebody else sitting there, a lawyer, sitting there saying, this is why the guardian ad litem needs to talk to this hospital today. But I submit to you, that had you really made sure this order was super specific in the beginning, you would need to file a subsequent motion unless something different comes up. I'm not saying that it, like I example with the translator, or there are times that you may be doing a home visit and you realize that there's a drug issue or that one of the parents has a mental health issue that you didn't know about and you really need to get those records and that wasn't anticipated because nobody knew that mom or dad had this issue. So I suggest that you review 61403 and make sure that your order initially has as much of it as the parties will agree to, and then subsequently as issues arise they can be brought before the court. It does talk about that, of course, you're able to review all the pleadings, talk to the witnesses. It is my experience that what I like to do is have, through their counsel, submit to me what they want. So that's what my starting place. I already know the pleadings. I've already, reviewed those. I want you to submit to me what you think I need to know for your position. So you have exhibits you want me to see, you have text messages, calendars, I get photos, and then you give me the list of who you want me to talk to. And I think it's important to know those things ahead of time. I usually ask on those initial consultations when I'm being retained for a guardian ad litem position, what is it that, how many people do you want me to talk to? What is the timeline? That's really important. Very important practice tip. Understand the timeline of your parties. If they're expecting you to be ready for a motion for temporary relief, you need to know that. If they're expecting you to just be ready for trial, you need to know that. If they're expecting you to be ready in one of those quick turnaround relocation hearings before a temporary relocation, you need to know that so that you can plan accordingly and really focus on getting done everything that is being requested of you. You don't want to come into a situation where you're seen as impartial because you had an opportunity to review all of the petitioner's witnesses, but not all the respondents' witnesses. That's going to not bode well. So make sure that you're managing your time, make sure you know your expectations, make sure you know what powers and authorities you have so you don't have to run into continued delays, do separate motions later on. Okay, next, 61.404. This one I am going to read to you. It's only a smidge. Look how little. Okay. Guardian ad litem's confidentiality. The guardian ad litem shall maintain, shall. I wish I had little graphics, shall, all bold, and I would probably say it in that overarching voice, shall, like that. The guardian ad litem shall maintain as confidential all, not some, not part, all information and documents received from any source described in Florida Statute 61.4032. Now remember, we had 403, 432 is when they talk about the guardian ad litem through counsel and petition. This is for the records, household members, wherever you're getting the information. Remember, they interlineate. And may not disclose such information or documents except in the guardian ad litem's discretion in a report to the court served upon both parties to the action and their counsel or as directed by the court. Have you guys ever heard of that phrase, cone of silence? The cone of silence, or even better in that one movie, what was it? Circle of Trust, is that it? The Circle of Trust. This is this. And I give you guys examples because I want you to remember. You know how in mediation, the reason that we all say it's confidential is because I don't want to make the offer that, hey, look, I'm basically willing to give you all the kids every day if I don't have to pay any child support. That's what, could happen. I don't want to look bad in court later because I don't want to say that in court. In court, I'm going to be the premier parent and I want my children all the time because I love them. Nobody can use against you what you said, right? That same premise and principle is there for guardian ad litems. I want Susie Cakes Johnson to tell me everything. Tell me why you think dad's not great. Tell me why you think Nana and Pop Pop are the ones who care for the child every day. Tell me why you think that mom is back, has fallen off the wagon from her substance abuse. Tell me why. And I don't want you to be afraid that I'm going to call you on the carpet and say, it's Susie Cakes Johnson. That's why I'm deciding that the kids should be with dad and not mom. You don't want that. You want people to be free and forthcoming. I want the teacher not to be afraid that she's the one who said that homework log is never signed by dad. Only the other parent, only his pop is the only person who signs the homework log. And then that teacher still has to see those kids. She still has to go to that school. This is phenomenal. This is your protection. This is one of your powers and duties, is confidentiality. It's important to remember. It's going to give you some peace of mind when you're going through the process. Okay, also peace of mind right here. One of the last kind of these connected statutes, which is the 61.401 through .405. Here's our last one. 61.405, any person participating in a judicial proceeding as a guardian ad litem shall, there we go, again, I wish I had a graphic, shall be presumed prima facie to be acting in good faith, and in so doing shall be immune from any liability, civil or criminal, that otherwise might be incurred or imposed. It's right there in black and white. I do love the law. Is that why we all became lawyers? I love it. I love it. I love it. It's thought out. It's protecting you. You are allowed to do your job without the fear that someone's going to sue you later. Now, let me talk to you plain, like how we talk to clients. This is the law. That doesn't mean that people don't break it. So that doesn't mean that pro se litigant Tommy Bobskins is not going to send you a civil suit because he thinks that you're working with the government. That can still happen. Can still happen. It just means you're going to have a good defense. Okay? All right. Now, we've gone over the statutes. We've gone over some of our Supreme Court forms. Let's talk about Florida Statute 6113, and we're doing good. We're about halfway through. Now, I'm going to go on a limb and say that everybody knows about 6113, but if you do not, this is like our Bible as domestic attorneys. We know these statutes in and out, and we know these factors in and out. These are the best interest factors. Now, as you all know, I think it was in 2008 that we got rid of our whole primary residential custody, and we moved forward towards parental responsibility and time sharing. So for parental responsibility, you often as a guardian ad litem will be asked to choose what method of parental responsibility will be best for the children. Now, we all know there's a presumption that shared parental responsibility is best, but I submit to you that I'm a really big litigator. So in addition to my guardian ad litem work, adoptions, and dependency, my family law cases are really contentious and complex, and I'm usually in court a lot for them. That being said, it's beneficial to hear some of our newer judges on the bench who talk about shared parenting. You've got to be able to talk. And it's good that they're truly looking at the application. And that's you also as the guardian ad litem. You can't just say, oh, shared parenting is the default, and so that's what I'm going to do. No. Is this going to work for this family? If you have two people who can't say the sky is blue, like can't look up. One person says it's blue and white and there's some yellow from the sun. Nope, it's just blue, you liar. If you have people like that, how are they supposed to confer and jointly make decisions? How? And the judges now are saying that. They're not just defaulting. They're not just defaulting to parental responsibility being shared. They're saying, you know what? Nope, I'm going to go and give Susie Cakes Johnson ultimate decision making. They're saying it. They're saying, not sole, we'll talk about that in a second, but ultimate decision making over education. She's the one who has the kid all the school year. And so we're not going to let Bob Joe come in here and say, oh, I don't like that teacher and I think you should switch him. No, you don't even know the teachers. Same thing for the parents with the special needs child. And the one parent has been the one who's gone to all the trainings, knows how to change all the mechanics for if the child is on kind of breathing machine, or knows all their medications, has been to all their doctor's appointments, knows who the caregivers are, what they should be doing. No, I'm not letting you make medical decisions because you don't know and you guys can't talk. So As a guardian ad litem, when you read through Florida Statute 6113, you need to really understand the real world application of what you're recommending. So if you recommend shared parental responsibility with ultimate decision making, we all know you can't just say that outright. The case law doesn't allow that. We can't just be like, ultimate decision making for the rest of your life. No, tell people what it is. Ultimate decision making over education, over religion, over health, over extracurricular. What are you telling this one specific area where someone's, FYI, constitutional fundamental rights that rear their child are now going to be limited? Tell them how and why. That's the parental responsibility. When you're considering the best interest of the child, you are considering who's going to be the decision maker about what, and you need to decide, does there need to be a trump card of that? Does there need to be someone's decision who trumps the other? If so, then say that and say why in your report. Also, you have to have the aspect of, is sole parental responsibility best in this? What if you're a guardian ad litem appointed where there's been someone who's in prison for, I don't know, next 10 years? Do you think, as a guardian ad litem, that they should still get to make choices? You can call him on the phone. You can call her on the phone. What's the difference? You don't get to see me in real life. In real life, we're not going to meet each other at Starbucks to make a decision about little Timmy's basketball. We're calling each other. Do you think it should be on basketball? Oh, I don't think it should be on basketball. Well, dadgummit, can't you just call me at the prison? Actually, I don't think you can. I don't think you just call it the prison. I actually don't think you can call. But doesn't mean that you can't send me a letter and I can't call you back. But you and I both know there's some delays. I'm giving a little bit of jest so we're not bored during this 50 minutes. But it's important to know that you're having someone here who can be available, responsive, and sincere in their thoughts for their child. So as the guardian ad litem, are you just going to say, no, mom doesn't get to make any of the decisions because she's in prison? Or are you going to say, no, I still think they need shared with ultimate. You got to try to reach out to mom. I've had a case where as a litigator, where sole parental responsibility was the most appropriate. And I was very excited that the court agreed with me. Not a case, of course, there's been several cases, but this particular case stands out because it was about non-responsiveness. And as a guardian ad litem, think of how many times that is what comes up. I reach out to that person, they don't respond. I reach out to that person, they don't respond. That comes up all the time. We all know that. And you're the guardian ad litem. You're the one who's going to be looking through all these text messages and say, oh, you know what? They're really not responsive. And if I'm asking you if little Susie Cakes needs her tonsils out, kind of need you to respond a little sooner. So I encourage you to learn these factors and be prepared to make a recommendation on shared parental, shared with ultimate decision making. Sometimes they'll call it shared with primary decision making. And then, of course, sole parental responsibility, which I always give the example as one is, do you think little Bobby should go to basketball? I do. I don't. Okay, we can't agree. Too bad. Do you think little Bobby should do basketball? I do. I don't. Well, I do, and I have ultimate decision making over extracurricular, so he is. Or do you think little Bobby should do it? Oh, wait, I didn't ask anybody. I just signed little Bobby up for basketball. That's how you can think of the three. Now, over here on the factors, they're going to go A through T. So just here all the way through, they always have that T of any other factor that's relevant. For me, I have found it's beneficial as a guardian ad litem to make a chart. And I kind of make like a chart that has all the best interest factors, what one side is alleging about mom, or mom and mom, or dad and dad, but what one side is alleging about one party and what they're alleging about the other. And then I have my factors and I'm going through and reviewing them kind of on a side by side. It helps me, and I make sure it's included in my report. It helps me to make sure that I'm not missing anything. And then I'm truly saying, like, this is a factor good for this parent, and this is a factor good for this parent. I have a parent, let's say, who has 4 DV cases. Obviously, the DV factor is not good for them. On the other hand, the other person maybe doesn't have any DV injunctions, but they have like a huge criminal case, tons of criminal records. Maybe that factor is not good for them. And then it gives me almost a quantifiable way for me to have a starting place to say, okay, well, out of these factors, 20 of them are bad for you and the rest are good for them. So it gives me a way to kind of quantify, and I like that. So I encourage you, make a chart, make what works for you, make a worksheet, so that as you're getting facts and you're gathering information, you could even kind of, as you're getting everything, put it in your respective piles. This is a moral conduct factor. This is a delegation of third parties factor. This is a stability factor. Oh, you know, I have 18 leases from grandma of where dad lived 18 different times. It helps you. Although, again, we know you can't use that against people. Everyone knows case law, but I'm just giving you an example. Okay, so that's 6113. Now let's talk a smidge about 6113.001, parental relocation. So you know, as a guardian ad litem, in just a standard domestic case, paternity, dissolution of marriage, modification, you're going to be relying on your factors. And honestly, you rely on these factors all the time. It's not just in those cases. It's also in the relocation factors, but you also have additional things to consider. That's it. So think of these two together. Okay. So 6113.01. The biggest thing to remember about relocation is it is not about you, Bobby, and it's not about you, Susie. How many times have you read these petitions for relocation? I need to move because I got a new job and I don't have a support system here and I'm really lonely and me. Isn't there a song, me? All about you. It's not. As a guardian ad litem, thank God, you get to say, no, this is the worst move ever for this kid. The child loves their school. They're making straight A's. They have siblings here. Dad is super involved. He sees him. They have equal time. And you want me to let you move to where? To California? How is that in the best interest of the child? I know it's going to be fantastic for you. How is it in the best interest of little Bobby and little Susan and little Tiffany and little Lucy Cakes? How? So when you're looking at parental relocation, you have to go through those considerations of whether this move is better. Now, again, remember I mentioned to you that I put a little bit of responsibility on the parties when I'm appointed, and back to what's in that order. See, we're just building and building. I put that responsibility on the parties to help me understand, what is it? Give me the documents. Is it that Bobby Cakes is doing horrible in this school and there's a school in Idaho that is much better and the classroom sizes are smaller? Tell me, is it that you don't have support and thus that's affecting little Bobby? Little Bobby's left at school at night? Like, tell me what it is. Help me see it in black and white. So you can have them provide you with statements. You're doing your interviews. They can give you the school records. But here's the key point. When in a petition for relocation, they have to tell us where they're going. And it's right here. Just come on back to petition to relocate. When you're reading this, it's telling you the telephone number of the new resident, when they're going to move, detailed specific reasons for the proposed relocation, a proposed relocation schedule for access and time sharing. P.S. People don't always follow this, which is frustrating as a practitioner and causes motions to dismiss. But more importantly, as a guardian ad litem, when you're in a relocation case, I need this information. Back to you're not an advocate. You get the petition, it's missing these things, right? It's not your job and it's not your role to say, Your Honor, FYI, they didn't follow the statute, so I think you should dismiss that. Not your job, Susan, not your job. Your job is to ask that person asking to move, hey, look, I have to make a recommendation of what's in the best interest of the children, and I need to make a recommendation of whether this relocation is in their best interest. Could you get me where you're going to live? Could you tell me who lives there? Could you get me some of these things? That's what you're asking. That's it, okay? Not your job to interject in the court. Your job is to get this information you need to be compliant with the statute. Okay, we're doing fantastic. All right, parenting plan. So again, Florida Supreme Court has parenting plan available for you. That's going to be form 12.995A. The standard parenting plan, as we all know, it has all of the little check markers. What are you doing? Is this established by the court? Where does everybody live? I think this is phenomenal for if you're making a recommendation of what a good parenting plan should be. If they submit dueling parenting plans to you and you need to look at them, I suggest that you go ahead and grab the initials form 12.9 95A, go through it and make sure all of these things are in it. You know, as a practitioner, and you also know from your experience, I'm sure, there are plenty of times we all get a parenting plan to work on the modification and say, so what did you guys decide about caregivers? Oh, it's not in here. What did you guys decide about where you're going to meet for the child? Oh, it's not in here. What did you decide about when you can call little Susie or Johnny? Oh, it's not in here. Take the parenting plan, the initial form, compare it to what you're being proposed by either side, or if they've asked you as the guardian ad litem to make a recommended parenting plan, be sure that you're including a bare minimum, which is from the Florida Supreme Court form. As I mentioned earlier, most of us have our own forms, and so we go through it and we already have what we're going to say as far as, like I try to include specific things about like the taxes, about providing income information, because as a practitioner, I'm thinking ahead for motions for contempt. I'm thinking ahead about people's income information. I put a lot of prevailing party language in it of this is what happens if you do this. I've been taught a lot at these CLEs to really make sure you're giving the judges alternatives. Don't just say, well, if Bobby breaks it, we want you to enforce it. Well, if he breaks it 5 times, I also would like for you to just invade his 401k, give us that money. Go ahead and say those kind of things. As the guardian ad litem, you're not advocating like myself as a practitioner in my forms, but what you are making sure is that you're preemptively thinking about what could happen for this child. What happens if you put in your parenting plan that they get telephone contact at 8 o'clock every day, but then lo and behold, mom or dad takes the phone as discipline? What is everybody supposed to do? You're the guardian ad litem. Think of the best interest of the child. Isn't it in their best interest for them to have contact with mom and dad? Isn't that good for them? Yes. Okay, so now you know it's good for them. How about you plan for that in your parenting plan? Make sure you have some contingencies. So start there. The supervised safety focus plan. This one, again, this is still in 63. So this is where we're in a domestic case. We all know that in a dependency case, that's going to be completely different. There's going to be a case plan that the parent with their regional counsel, or if they have private counsel, is going to be working through, and that there's going to be motions for reunification, motion for contact, motion for time sharing, motion for out-of-state contact. We all know that's going to go through the department and their case management system. Here, when there's just an element of some supervised safety, for example, I've had cases where you had one parent with severe mental health issues, and we want to make sure that mom or dad is taking their medication. We want to make sure they're in compliance with their treatment plan. We want to make sure that we have access to those records, that they're not going to raise a HIPAA objection to us. These things right here are good to consider for a supervised safety focus plan. And I say again, as the guardian ad litem, whether or not you're being asked to make a recommendation on submitted parenting plans to you, or if you're being asked to create a recommendation of what the parenting plan is, you have got to make sure that you're starting with the skeletons of the Florida Supreme Court forms, because otherwise you're going to miss something. It's, brand new starting out, you will miss something. We all know with experience is how we continue to expand what we would include. For example, in the safety plan, there's things like access to activities. Okay, we have somebody who's coming to the soccer games. How are we doing it? Can you go on one day? Can I go on the other? Children's safety, no alcoholic beverages, no firearms. How are we doing the discipline? That is a consistent concern. Oh, I don't want you to spank. Well, in the state of Florida, you're allowed to spank. So is it that you don't want me to spank? And if so, then you need to put it in writing, because otherwise I'm protected to do it. Okay. Supervised safety focus plan. That's Florida Supreme Court Form 12.995B. Then, of course, we talked about relocation. The relocation plan is Form 12.995C. This relocation plan, again, I am imploring you that as you are going through your recommendation, you consider these things in your report. I know that the reports take a long time, right? I write them. I know they take a long time, but it's beneficial, because when you're reading it initially, that initial reaction, that initial gut of what you think is good for this child or not, it's going to be cumbersome to go back. And I mean, just think, we've only been on this for 44 minutes. Look how much we've gone through. You're the guardian ad litem. Don't you think that mom and dad are going to inundate you with like tons of paperwork and interviews? So when you're really sitting down to make a recommendation, it helps to have like a checklist, which is why I mentioned for the best interest factors, have checklist, have a chart, have some kind of summary or guideline that you can follow. The Supreme Court forms are really good for, again, just reminders of what you want to do, who's paying for these flights, can Bobby Joe fly alone? What happens if there's a national pandemic? Is Bobby Jones still going to fly? Bobby Jones not going to fly? Bobby Jones getting on a train? Who's paying for the train? Who's keeping little Bobby Joe's super passports? Can I apply for a new passport? What are we gonna do if little Susie Cakes wants a dual citizenship? Mom wants to apply for that. Is that in little Susie Cakes' best interest? These are the things to consider when we talk about relocation, when we talk about any parenting plan, and recommending the same for the children. All right, now we are doing phenomenal. I will tell you we are at the last 5 minutes, so you can feel like, woo, got through the first session of the CLE. We're doing it. Okay, guardian ad litem initial report. So I pulled one of my old reports just to kind of go over to you what I include. I always outline who they asked me to interview and whether or not I got to do those interviews. So I start with what I reviewed, and I put all this in my report. And everybody's different. The same way there's different practitioners, there's different guardian ad litems. I'm a little bit type A OCD. It helps me, again, to be able to say, nope, this is where I saw it. This is where I got it from. So I outlined every single document that was given to me. Think of an index. I put like a table of contents index in here. I outlined every single person that they asked me to interview. I outlined when I interviewed that person, what the relationship was. I outlined all the medical professionals, what information I received, what documents I reviewed. I outlined my home visits, and I go through the best interest factors, like I mentioned to you, line by line, factor by factor, of whether or not this was good for mom. In this case, it was mom and dad, mom and dad, mom and dad, what was good for them, what was not. I go over what documents are interlineated, why I chose this, what was helpful to me, what was not helpful. If I have any updates, then I outline that, hey, look, since I've written this report, you can do supplemental reports. Don't forget that. You can do supplemental reports. You can amend your report. You can do preliminary reports. The sky is the limit. I know people think that it's just one and done and you make your recommendation and that's it. Guardian ad litems are a party to the case. I can't tell you how many times you have clients who reach out and say, I want the guardian ad litem to know this. The guardian ad litem said I was supposed to have Tuesdays and Thursdays. Everybody, the judge agreed with the recommendation, made it a court order, and I want the guardian ad litem to know she's breaking this. And it was on a temporary basis. I want her to know before she makes her final recommendation. So you may have updates. You may have supplemental reports. I did outlining on my recommendation of the residence where I thought the child should reside. That was what I was asked for. Again, in my order, I knew what I was being asked of. I knew what specifically, remember that order appointing that we talked about, and it said, what did you want the guardian ad litem? What are they talking about? What did you want the guardian ad litem to make a recommendation on? I can't just have like an open-ended, we just want you to tell us what you think. No, what do you want me to tell you about specifically? Make that qualification for yourself in that standard. So I was asked to recommend where the child should reside. I made that recommendation. I was asked to recommend a time sharing schedule, and I made that recommendation. So this is one of my past reports. And so again, I think we'll have a redacted version in the materials for you all. This is the time that I would ask for, of course, any questions, but instead I'm going to give you a couple of tips for our last 2 minutes, which some of the tips are, 1, I suggest that you do your interviews first before you read the documents. That's my tip. It helped me frame things. Now, everybody's different, right? For me, I didn't want to go in with a preconceived notion of like, I read your text messages. I see that you're a controlling person or what have you. Or I've read the school records. I know that little Bobby's failing. You can lie to me if you want. I appreciated doing the interviews first of those people they requested, the teachers, the cousins, the friends. It helped me. After I do the interviews, then I did the document review. And then from that, I did my site visits. And that order just helps me funnel it, come up with what works for you. Also, a tip that I will give you is to make sure that you understand how these real world examples, like I mentioned for guardian ad litem, it can be more than just domestic cases. I have had cases, like I said, where you make recommendations on funds, on people's money, on settlements, on PI cases and guardianship cases. So allow yourself to know that there are some additional ways that you can create revenue as a private guardian ad litem, and it will assist you in making sure that you are expanding, again, your experience. So I won't keep you any longer. Like I said, my name is Jessica Thomas, owner and operator of the Thomas Law Firm here in Central Florida, where I service all neighboring counties in the areas of family law, guardian ad litem, adoption law, dependency, anything domestic comes to me. I am so happy to have been able to talk with you today, and I appreciate your time. I appreciate you joining us for this certified legal education credit. And if you have any questions, my information is probably on the materials, and I'd be happy to help you, give you some insight. Give me a call. Jessica Thomas, Thomas Law Firm.
Hi, welcome. My name is Deborah Poindexter. I'm an attorney licensed to practice law in the state of Florida. I'm also licensed to practice law in the United States District Courts for the Middle District of Florida and the Northern District of Florida. I've been practicing law since 2004, primarily in the areas of family law and eminent domain. I began accepting guardian ad litem appointments almost immediately after being admitted to the Florida bar. I've accepted appointments in private domestic relations cases, as well as juvenile cases and mortgage foreclosure cases. Since the format of this presentation is by video, if you have any questions or if you'd like me to clarify any of the information during my portion of the presentation, please do not hesitate to contact me. If you'll visit my website at poindexterlaw.com, you'll find the Contact the Attorney button that will allow you to generate an email to me, or you may email me directly at deborah@poindexterlaw.com, or simply you can pick up the phone and call me. My phone number is 407-478-1001. My portion of the presentation is focused on a couple of topics as it relates to guardian ad litems. The first part of my presentation is related to collaborative partnerships in domestic relations court, and the last part of my presentation is related to two stages a guardian ad litem is involved in domestic relations proceedings: pleadings and hearings. More specifically, what a guardian ad litem needs to do in order to be prepared when asked to defend his or her recommendation in court. There are various types of individuals that can get involved in a domestic relations case that can assist the court in making decisions regarding timesharing and other parenting issues that may come up. These are, of course, court-appointed individuals, and examples include guardian ad litems, attorney ad litems, social investigators, and parent coordinators. Sometimes it's beneficial to create collaborative partnerships with these various parties in domestic relations cases involving a guardian ad litem. So let's talk a little bit about these various parties that I just identified. They too can be involved in domestic relations cases along with guardian ad litems, so that you can see the differences between them and what a guardian ad litem does, what he or she, their role. As we already know, a guardian ad litem's power and authority are governed by Florida Statute 61.403. A guardian ad litem, when appointed, shall act as next friend of the child, investigator or evaluator, not as attorney or advocate, but shall act in the child's best interest. A guardian ad litem shall have the powers, privileges, and responsibilities to the extent necessary to advance the best interests of the child. Even though a guardian ad litem may be a member of the Florida bar, that guardian ad litem is not an attorney for the child. So let's talk specifically about an attorney ad litem's role. An attorney ad litem can be appointed as a legal representative for the child or the children in a domestic relations case where you might serve as a guardian ad litem. Just like a petitioner or respondent can have an attorney representing a client's interests in a domestic relations case, an attorney ad litem acts as an attorney for the child or the children. In a domestic relations case, an attorney ad litem, when appointed by the court, protects a child or children's specific legal interests. As the guardian ad litem, you can recommend the need for an attorney ad litem to be appointed for the minor child or children in your case. In the event the legal rights of the child becomes an issue, then the services of an attorney on behalf of the child would likely be needed, and the court may be required to appoint an attorney ad litem for the child or the children. An attorney ad litem can seek to advance the child's or children's expressed thoughts and wishes, even when those same expressed thoughts and wishes are contrary to the child's best interests. Examples might be protection of the child's psychotherapist patient privilege, protection of the child's doctor-client privilege, protection of the child's constitutional rights. Next, let's talk about social investigators. A social investigator makes recommendations in a domestic relations case as an expert in the case. A social investigation is conducted by an individual who is appointed by the court and acts as an impartial professional. A social investigator can be a licensed therapist, a psychologist, an attorney, or a certified social worker. A person appointed to conduct a social study investigation is not a party to the litigation, but instead acts as an expert witness in the case. On the other hand, a guardian ad litem actually becomes a party to the litigation and is entitled to attend all court proceedings and depositions, file motions or other pleadings with the court, question witnesses at proceedings and depositions, and receive all notices of any activity in the court case to which a party is entitled. Both a social study investigator and a guardian ad litem will generally have access to medical records, school records, and other records related to the child and the parents. The guardian ad litem and the social investigator will also be able to interview the parties, the children, and other witnesses, including teachers, doctors, etc. If the social study investigator is a psychologist, the investigation will often include a psychological evaluation of the parties and/or the child. A guardian ad litem may also request that psychological evaluations be performed or that other expert examinations of the parties or the child or the children be performed. Both a guardian ad litem and a social study investigator generally prepare a written report for the court, but a guardian ad litem report is not automatically admissible into evidence, whereas a social study investigator report under Florida Statutes Chapter 61.20 is not subject to the rules of evidence. Since such reports will generally contain hearsay, which is not often admissible in court, this can result in a guardian ad litem report not being admitted into evidence, whereas the social study investigation reports are often admitted into evidence, since they are not subject to the rules of evidence. We will talk a little bit later about waiving the hearsay exception. Next, let's talk about parent coordinators. Parent coordinators are also court-appointed and can also make recommendations to the court. In Florida, parent coordinators are required to be either mental health professionals or attorneys. A parenting coordinator assists the parties in developing or implementing a parenting plan most effective for that particular family's needs. Parent coordinators are often appointed when parents need assistance with compliance of time-sharing arrangements or following the parenting plan, or sometimes they need assistance in resolving disputes in a timely manner. When both parents agree, parent coordinators can also make temporary decisions on child-related issues to immediately resolve parents' conflicts. In contrast, the guardian ad litem investigates and ultimately makes recommendations based on his or her findings. She does not help the parties in creating a parenting plan. That does not mean that a guardian ad litem cannot assist with time-sharing conflicts, but ultimately, her recommendation to the parties or the court is just that. It's a recommendation. Typically, a parenting coordinator assists with fostering communication and problem-solving skills between the parents. A parent coordinator is also helpful in counseling parties on the underlying issues that cause the parental conflict. Parties can be ordered to attend parent coordination, and sometimes a guardian ad litem recommends that they do. It is very helpful to have a very specific duty or duties included in an order of appointment related to the parties' participation in parent coordination. Court appointment eliminates the possibility of either party firing the parent coordinator before the recommendation for visitation is made. Court orders should contain duration with the parent coordinator as well as a goal or goals to accomplish if possible. To eliminate confusion by the parents, parenting coordinators, attorneys, or the guardian ad litem in a case about the specific duties of a parent coordinator, a very specific order is necessary. As a guardian ad litem, it is not your role to facilitate agreements between the parties. As a guardian ad litem, it is also not your role to aid in compliance of time-sharing arrangements or following the parenting plan or providing assistance in resolving disputes in a timely manner. However, sometimes if the parties know what you will ultimately be recommending to the court, that can assist in getting parties to agree ahead of time. Next, let's talk about expert mental evaluations. As a guardian ad litem, you are authorized to request the court to order expert examination of parties to a case. Florida Statute 61.4033 states that the guardian ad litem, through counsel, may request the court to order expert examinations of the child's parents, or other interested parties in the action by medical doctors, dentists, and other providers of health care, including psychiatrists, psychologists, or other mental health professionals. Florida Statute 61.4034 states that the guardian ad litem may assist the court in obtaining impartial expert examinations. These can be, as an example, a psychological evaluation or a psychiatric evaluation. A very broad stroke to describe a psychological evaluation is that it is a mental health assessment. Another very broad stroke is to describe a psychiatric evaluation as the process of gathering information about a person with the purpose of making a diagnosis. One of the major differences between a psychological evaluation and a psychiatric evaluation is the use of standardized tests in a psychological evaluation. Psychological or psychiatric testing may play a role in cases where you might be involved as a guardian ad litem, even when mental health isn't a glaring concern for either parent or the child or the children. If, during your investigation, you believe that the court may need to accurately assess the parenting capability of each parent and determine whether a parent's mental state poses a risk to the children's safety, it may be appropriate to request a mental evaluation to further the best interests of the child. Next, let's discuss two very important stages a guardian ad litem is involved with in a domestic relations proceeding: pleadings and hearings. More specifically, what do you as a guardian ad litem need to do in order to be prepared when asked to defend or support your recommendations in court? Florida Statute 61.4031 states that the guardian ad litem may investigate the allegations of the pleadings affecting the child, and after proper notice to interested parties to the litigation and subject to conditions set by the court, may interview the child, witnesses, or any other person having information concerning the welfare of the child. So how do you get started so that you are adequately prepared for a hearing or to file pleadings? Investigation, preparation, and planning is key. Preparation for a report and recommendation that you will draft begins at the beginning of a case. Start with your initial communication with the parties and the parties' attorneys if they are represented by counsel. Set an expectation with the parents from the beginning regarding how you will spend your time. If they give you a list of 15 cousins that they want you to talk to that are going to all tell you the same thing, explain that you will also have to bill accordingly. Have the parties provide all names and contact information for any person they think may assist you in making a recommendation in the case. Typically, the parties will provide you the following people: family members, neighbors, friends, caregivers, other individuals in the community who have seen either that party interact with a minor child or the other party, other individuals that a party thinks they feel is important for the guardian ad litem to speak with. The initial meeting is a good way to flesh out the reasons why they've included someone on their list. I always ask, what is this person going to tell me? I always ask, why is it important to you that I speak to that person? I always ask, how is this going to help me in making a recommendation in the case? I always document the contact during the conversation, the date, the time, the duration of the call. During this initial communication, it's also a good idea to get information regarding the time expectation so that you can plan accordingly and be efficient, if necessary. Is this a case that needs a report and recommendation in a short period of time? Are there issues that need to be addressed immediately? Are there interim agreements that have already been made between the parties? Have the parties been to mediation? Has the case been set for trial? I'd like to talk to you about records requests by guardian ad litems in domestic relations cases specifically related to school and medical records. We've previously discussed a guardian ad litem's right pursuant to Florida Statute 61.4032 to inspect and copy any records and documents. Related to that statute is Florida Statute 61.404 regarding the guardian ad litem's duty of confidentiality. That statute states the guardian ad litem shall maintain as confidential all information and documents received from any source described in 61.4032 and may not disclose such information or documents except in the guardian ad litem's discretion in a report to the court served upon both parties to the action and their counsel or directed by the court. I have over the years refined my proposed order of appointment to include specific language that essentially allows me to do my job. There is nothing worse than getting appointed as a guardian ad litem and the roadblocks appear that get in your way of getting information that you need in order to make a recommendation in a case. Those roadblocks sometimes are parties, non-parties, sometimes they're attorneys. I include language in my proposed order of appointment that covers all of my bases. You'll see in my sample proposed order the bucket list of individuals and entities that I include. I also include any individual employed at any of the entities referenced in order to gain any information related to the minor child, regardless of confidentiality or non-public classification status. I also include a catch-all phrase: the guardian ad litem shall perform such other duties and undertake such other responsibilities as this court may direct. As it relates specifically to school documents that you're trying to gain access to, I have learned over the years that sometimes you can just show up at a school, but sometimes it's best that you don't. Specifically for schools, call to find out what their process is for gaining access to either records or the child. If you just show up, although you're entitled to the information that you're looking for, it just may not be available. There may be testing, there might be a school event that might otherwise make the individual who would ordinarily assist you be unavailable. I have found that scheduling a time with the school works best, typically. Also, visiting the child at school is helpful if necessary. The things that you might consider: how do they appear? Are they well groomed? Do they seem rested? Do they seem hungry? Let's talk a little bit about pleadings, interim reports, and recommendations, and joint stipulations entered into during the pendency of a case. Florida Statutes 61.4036 states that a guardian ad litem acting through counsel may file such pleadings, motions, or petitions for relief as the guardian ad litem deems appropriate or necessary in furtherance of the guardian's function. Florida Statutes 61.4036 also states that the guardian ad litem through counsel is entitled to be present and to participate in all depositions, hearings, and other proceedings in the action, and through counsel may compel the attendance of witnesses. As it relates to an interim report, if an issue arises during the investigation that you think needs to be addressed now or would be beneficial to be addressed now, then you can file an interim report and recommendation. Before any interim report and recommendation is filed, the guardian ad litem has the ability to contact the attorneys and/or the parents directly to seek their cooperation in implementing a recommendation during the pendency of the case for the benefit of the child. During the pendency of the case, the parties may come up with a joint stipulation regarding the children or child for which you've been appointed. Florida Statutes 61.4036 states that the guardian ad litem shall submit his or her recommendation to the court regarding any stipulation or agreement, whether incidental, temporary, or permanent, which affects the interests or welfare of the minor child within 10 days after the date of the stipulation or agreement is served upon the guardian ad litem. Now let's turn to final reports and recommendations. Final reports and recommendations are governed by Florida Statute 61.4035. That statute states that the guardian ad litem may address the court and make written or oral recommendations to the court. It also states that the guardian ad litem shall file a written report which may include recommendations and a statement of the child's wishes. The report must be filed and served on all parties according to the statute at least 20 days prior to the hearing at which it will be presented unless the court waives such time period. The guardian ad litem must be provided with copies of all pleadings, notices, and other documents filed in the action, and is entitled to reasonable notice before any action affecting the child is taken by either of the parties, their counsel, or the court. Before any final report and recommendation is served on the parties, I typically like to contact the attorneys and/or the parents directly to seek their cooperation in implementing the recommendations that I provided in the final report and recommendation for the benefit of the child. Sometimes that conference settles matters between the parties without the necessity of the hearing, since they know what I'll be recommending. Sometimes it doesn't. So what do you include in the final report and recommendation? I would suggest you be as organized in the presentation of the information so that it's easy to follow. I organize my reports and recommendations as follows. Case histories first, then parties information, including the type of contact and visits. Individuals that were interviewed, followed by documents that were reviewed, summary of the child information, summary of the witness interviews. Summary of the parties' perspective is also very important to include. Considerations, and then finally the ultimate recommendations I make. In the case history section, it's important to include the relevant case history. In chronological order, tell what's happened in the case. I like to include relevant filing dates and pleadings, motions, or major rulings made by the court. In the parties information section, I include the type of contact that I had with the parties. Was it in person? Was it by phone? Where did I meet with the parties? Where did I meet with the child? In the section where you list individuals that were interviewed, make sure you identified who you spoke to and who was the source of the contact. Was it mom or dad or a collateral source that provided you with that information? Include any contact that you were provided but that you were not able to make contact with. There's nothing worse than when a party gives you a witness to contact and interview, but you can't get a hold of that witness. In cases like that, I like to include any attempts that I have made to contact that person that were not successful. In the section regarding documents that you reviewed, be as specific as you can in describing the document. If it was a letter, include the date of the letter. Include range of dates if you were provided, as an example, text messages from various dates. Identify with specificity the documents that you reviewed. Were they school records? Were they medical records? Were they text message communications? Was it Facebook pages? And the like. In the summary of the witness interviews, you should include all witnesses that you spoke with. This summary is where the guardian ad litem summarizes and identifies what was learned from the various witnesses. Here is where you include facts that you actually learned during your investigation. Remember that a fact that you include should support your ultimate recommendations in the case. If a fact does not support your ultimate recommendation, I suggest you just leave it out. Include information that you also may have learned from professionals, so long as you are at liberty to discuss those. In the summary of the parties' perspective, include what they both have shared with you. You can even include nice things that they've reported to you, especially if it assisted you in making the final recommendation in the case. Both parties should have shared with you their concerns about the other party. Include that in your report as well. Make sure both parties' allegations are included so that both parties feel heard. In the summary of the child section, you may include the child's stated preference if he or she has made one. Try to include the reason for the preference if at all possible. The child's perspective is the most important perspective that you include in the report and recommendation, since the child will not be present at the proceeding to voice his or her own perspective. That, of course, is the ultimate reason why you are appointed in the case. You're probably all wondering when we're going to get to the consideration factors. Well, here we are. Florida Statute 61.13.3 states that for the purpose of establishing or modifying parental responsibility and creating, developing, approving, or modifying a parenting plan, including a time-sharing schedule which governs each parent's relationship with his or her minor child and the relationship between each parent with regard to his or her minor child, the best interest of the child shall be the primary consideration. A determination of parental responsibility, a parenting plan, or a time-sharing schedule may not be modified without a showing of a substantial, material, and unanticipated change in circumstance and a determination that that modification is in the best interest of the child. Determination of the best interest of the child shall be made by evaluating all of the factors affecting the welfare and interests of the particular minor child and the circumstances of that family. In drafting a final report and recommendation, in order to determine the matters contained in the report and recommendation that is in the best interest of the children, I consider all factors articulated in Florida Statute 61.13.3. I specifically include every factor, articulate who the factor favors, and the analysis that got me to decide why the factor favored one parent or the other. Sometimes the factor favors neither parent, and I will state so. So let's dive in and talk about the 15 factors articulated in Florida Statute 61.13.3. A. The demonstrated capacity and disposition of each parent to facilitate and encourage a close and continuing parent-child relationship, to honor the time-sharing schedule, and to be reasonable when changes are required. I always first identify who the factor favors. For example, this factor favors the mother, or this factor favors the father. I always include an analysis from both parties' perspective as well. Don't feel the need to only include negative items. If the parties actually do facilitate and encourage a close and continuing parent-child relationship, then acknowledge it. That's great. B. The anticipated division of parental responsibility after the litigation, including the extent to which parental responsibilities will be delegated to third parties. Again, identify who the factor favors. Things you might consider here. Who is utilizing third parties? If so, is it reasonable? If it's just aftercare, everybody uses aftercare. Who is helping with homework? Is the other parent more available to care for the child? C. The demonstrated capacity and disposition of each parent to determine, consider, and act upon the needs of the child as opposed to the needs of the parent. Things you might consider here. Are the parents sensitive to the needs of the child first? D. The length of the time the child has lived in a stable, satisfactory environment and the desirability of maintaining continuity. Things you might consider here. Does one party move more than the other? If so, why? Is it a reasonable explanation for all the moving? Are they simply unstable? E. The geographic viability of the parenting plan, with special attention paid to the needs of school-aged children and the amount of time spent traveling to effectuate the parenting plan. This factor does not create a presumption for or against the relocation of either parent or child. Things you might consider. Does it make sense to have a substantial time sharing if one party lives an hour away from the children's school? Think about it. We find ourselves at F, the moral fitness of the parents. What is moral fitness? Things you should consider. A person's behavior regarding violence, particularly a conviction of domestic violence, dishonesty, substance abuse, conviction of sexual crimes, and child abuse. G. The mental and physical health of the parents. Things you might consider here. Have there been mental health issues? Have there been commitments? Are there any underlying mental or physical health problems that would interfere with a parent's capacity to care for the child? Now we're at H, the home, school, and community record of the child. Things you might consider for this factor. Are the children involved in outside activities? Do the parents know the teachers? Do the teachers know who the parents are? Are people outside of the home familiar with the children and the family? Item I is the reasonable preference of the child if the court deems the child to be of sufficient intelligence, understanding, and experience to express a preference. Things you might consider here. There's no magical age that determines when a child can articulate a preference. This is simply a case-by-case matter. For me, sufficient intelligence, understanding, and experience to express a preference is typically fleshed out after a few meetings with the child. Tune into the difference between a preference and an encouragement that a child might be receiving from one parent or another. J. The demonstrated knowledge, capacity, and disposition of each parent to be informed of the circumstances of the minor child, including but not limited to the child's friends, teachers, medical care providers, daily activities, and favorite things. Typically, this is pretty easy to determine. Who's your child's BFF? Who's your child's homeroom teacher? What is the name of your child's pediatrician? At what dental office is your child seen? What night and time is your child's dance class? K is the demonstrated capacity and disposition of each parent to provide a consistent routine for the child, such as discipline and daily schedules for homework, meals, and bedtime. Typically, this can be based on observations during an in-home visit. Don't mistake, however, parenting styles with inconsistency. You may have one very strict parent and one parent that's not so strict, kind of loosey-goosey. They may also be nervous to be observed during the home visit. After observation, you can also piece together the information by asking the parties separately about what their impression of their schedule is. L is the demonstrated capacity of each parent to communicate with the other and to keep the other parent informed of issues and activities regarding the minor child, and the willingness of each parent to adopt a unified front on all major issues when dealing with the child. Things you might consider. Is one parent making unilateral decisions regarding medical appointments? Is there a third party transporting children to medical appointments before asking the other parent if they're available? Does the other parent know that there's a play next Tuesday? Does the other parent know that the child failed chemistry last week? If the child loses his phone privileges at one parent's house, what happened to the child's phone privileges at the other house? Does the child know that the parents don't communicate? M. Evidence of domestic violence, sexual violence, child abuse, child abandonment, or child neglect. This is self-evident. It either exists or it doesn't. N. Evidence that either parent has knowingly provided false information to the court regarding any prior or pending action regarding domestic violence, sexual violence, child abuse, child abandonment, or child neglect. This is also self-evident. O. The particular parenting tasks performed by each parent and the division of parental responsibilities before the institution of litigation and during the pending litigation, including the extent to which parenting responsibilities were undertaken by third parties. Things you might consider. How has the filing of the action changed the parties' roles, if at all? P is the demonstrated capacity and disposition of each parent to participate and be involved in the child's school and extracurricular activities. Things you might consider for this factor. How are the parents involved in the child's school and extracurricular activities? Do they each participate in the watching of the sports? Do they keep each other informed? Does one or the other not care to attend? Q. The demonstrated capacity and disposition of each parent to maintain an environment for the child which is free from substance abuse. This is self-evident. Either it happens or not. R. The capacity and disposition of each parent to protect the child from the ongoing litigation is demonstrated by not discussing the litigation with the child, not sharing documents or electronic media related to the litigation with the child, and refraining from disparaging comments about the other parent to the child. Things that you might consider regarding this factor. What has either parent shared with the child regarding the case? What does the child know? How do you find out what the child knows about a case without telling the child about a case? Do you know who I am? Or maybe that's the type of question that you ask. Has anyone told you what I'm going to talk to you about? S. The developmental stage and needs of the child and demonstrated capacity and disposition of each parent to meet the child's developmental needs. Things that you might consider for this factor. What are the child's needs? What are the parents' capacity to meet those needs? What are the parents' dispositions to meet those needs? T. Any other factor that is relevant to the determination of a specific parenting plan, including time-sharing schedule. Things that you might consider. Distance between the parties that may or may not allow for children to be exchanged midweek. Extended relatives living in the home. In the recommendations section of your report, you should include your very clear and specific recommendations in the case. The order appointing you should have included very clearly stated the areas to which recommendations were sought. Examples of those areas may include parental responsibility of the children, residence of the children, time-sharing schedules, ultimate decision-making authority regarding medical, education, or religious matters, and contact by the parents with each of the minor children. Whatever the areas are that you were asked to make a recommendation on, I would recommend that you address each area as a separate paragraph. Now we're getting to the good part. It's time for you to testify at a hearing. You must attend any proceeding if your recommendation regarding the children will be useful to the court in making a determination on the subject of the hearing. Sometimes there are hearings that take place that don't have anything to do with the children. Your decision to attend that type of hearing could be as an investigation tool. Hearings are a great time to observe interactions between parties. Hearings are also a great time to check demeanor and credibility when a parent is testifying. When it is time for you to testify, be prepared. Review your reports. Don't try and memorize your report. Take a copy with you to help you refresh your recollection. Review your witness interviews. This might sound silly, but know the parties' names. And this might sound even more silly, but know the children's names and their dates of birth. Attorneys that are not happy with your recommendation will use your testimony as an opportunity to show the court that you don't know anything about the parties or the child. It is important to not allow anyone to intimidate you or to question your reasoning. Remember to stick to the facts when you're testifying. Don't use the hearing as the time to talk about something that was not included in your report. This is not the time to become hostile or defensive with either of the attorneys. Give yourself the same advice that you would give to a client before a hearing. Do not become emotional. Keep your emotions in check. Be truthful in your answers. Be direct in your answers. You may answer yes, no, or I do not recall, so long as those responses are truthful. If you do not know the answer to the question, that's okay. If you do not understand the question, that's okay. Just tell the attorney. Do not speculate about what an attorney is trying to ask you. And pay attention. A guardian ad litem has the right and duty to ask questions of the witnesses, including the parties. Sometimes, as a guardian ad litem, you're seated in a very odd location in the courtroom. Do not let them forget you're in the courtroom. You are a party to the case. If you are requested to bring records or documents, gather and organize them and be ready to provide them for review. But remember, under the statute, all of your information and documents are confidential unless in your discretion it has been used in your report. Let's wrap this up by discussing the order discharging you as the guardian ad litem in a case. You can be discharged from the case at the conclusion of a case, obviously, upon your motion to be discharged prior to the conclusion of a case, or if a party requests that you be discharged prior to the conclusion of a case. The best way to handle your discharge is to include it in the order of appointment. If there is no language in the order appointing you regarding your discharge, please make sure you make the court aware and that you are a part of the reviewing of the proposed order resulting from the final hearing. I suggest 30 days from the order issued from the proceeding where your report and recommendation was the subject. Another suggestion is that if there are outstanding fees owed to you at the final hearing, then ask the court to allow you to reserve the right to come back for enforcement in case you don't get paid. Sometimes it may be necessary to request your discharge prior to the conclusion of a case. Examples might be a conflict of interest, an inability to perform your duty, or non-payment by a party when it has been court ordered. Sometimes a party will request that you are discharged because they are dissatisfied with your recommendation or what they believe will be your recommendation in the end. In these cases, the guardian ad litem will typically only be discharged upon a showing of good cause, such as bias, conflict of interest, or failure to perform the duties of the appointment. The burden to show a reason for a discharge is on the party filing the motion. This concludes my presentation. I hope that you have enjoyed this portion of the program as much as I have enjoyed presenting. I am truly passionate about serving as a guardian ad litem. I hope that the information that I have shared with you today is helpful to you as you accept guardian ad litem appointments. I hope that you have as much passion and joy as I do representing children in domestic relations cases. Sample copies of my preferred order and guardian ad litem report will be provided as a part of this program. As I said to you early on in my presentation, if there are any other questions I can answer, please do not hesitate contacting me. It's been a pleasure serving as a speaker to you today. Thank you. You are probably all wondering when we are going to get to the considerations. Well, here we are. There are 15 factors affecting the welfare and interests of the child and the circumstances of that particular family to consider in order to determine the best interests of the child that you will include in your report and recommendation. Florida Statute 61.133 states that for the purposes of establishing or modifying parental responsibility and creating, developing, approving, or modifying a parenting plan, including a time-sharing schedule which governs each parent's relationship with his or her minor child and the relationship between each parent with regard to his or her minor child, the best interest of the child shall be the primary consideration. A determination of parental responsibility, a parenting plan, or a time-sharing schedule may not be modified without a showing of a substantial, material, and unanticipated change in circumstances, and a determination that the modification is in the best interest of the child. Determination of the best interest of the child shall be made by evaluating all of the factors affecting the welfare and interests of the particular minor child and the circumstances of that family. So let's talk about the 15 factors articulated in Florida Statutes 61.133. A, the demonstrated capacity and disposition of each parent to facilitate and encourage a close and continuing parent-child relationship, to honor the time-sharing schedule, and to be reasonable when changes are required. Identify who the factor favors. Does it favor the father? Does it favor the mother? Then you'll want to include your analysis from both parties' perspectives. Don't feel the need to include negative items. If the parties actually do facilitate and encourage a close and continuing parent-child relationship, then acknowledge it. That's great. Things to consider. Does one parent or both encourage relationships with the other parent and the child? Does the parent caring for the child allow contact with the other parent while the child is in their care? Does the child feel free to communicate with the other parent while in the care of one parent? Do the parties abide by their actual timesharing agreement? Is one parent or the other always late? Is one parent or the other always changing the pickup or drop-off plan? Are the parties reasonable if changes need to be made? Do the parties accommodate changes, or is it a battle to do so? Is one party declining changes in order to control the other person's schedule? Do parents honor special requests for birthdays, additional time, time with the child's friends or extended relatives, etc.? B, the anticipated division of parental responsibility after the litigation, including the extent to which parental responsibilities will be delegated to third parties. Again, you want to identify who the factor favors. It favors the father. This factor favors the mother. Things you might want to consider. Who is utilizing third parties? If so, is the delegation of responsibility reasonable? Is the third party aftercare or before care? Is the third party caring for the children on weekends so that a parent can have his or her own social life? Who is helping with homework? Prior to the proceeding, were the parties already delegating children responsibilities to third parties? C, the demonstrated capacity and disposition of each parent to determine, consider, and act upon the needs of the child as opposed to the needs of the parent. Parents and children all have certain needs. It's been said that in order to care for others, you have to make sure that as a parent that you care for yourself first. You've all been on planes where the airline attendant tells you that in case of an airplane emergency, if the plane starts to go down, you should put your oxygen mask on first before that of your child's. Well, domestic proceedings can sometimes seem like a plane is going down. And there are certain parental needs that should take place. Parents have certain physical needs related to food, water, and shelter. Parents have a need for social contact with other people. Does that need for social contact with other people spill over into the time that they have with their children? If the party has every other Saturday with the child, but they have dinner every Saturday with their friends, is that appropriate? Things you might consider. Are the parents sensitive to the needs of the child first? Does the child have his or her own space at each parent's residence? If a child has a dietary restriction or lifestyle, is it honored at both residences? Do parents try to have consistency with the child's friends from school? D, the length of time the child has lived in a stable, satisfactory environment and the desirability of maintaining continuity. Things you might consider. Does one party move more often than the other? If so, why? Is there a reasonable explanation for all the moving around? Does one party have roommates or friends or significant others that come and go from the residence? E, the geographic viability of the parenting plan, with special attention paid to the needs of school-aged children and the amount of time to be spent traveling to effectuate the parenting plan. This factor does not create a presumption for or against the relocation of either parent or child. Things you might consider. Does it make sense to have a substantial time sharing schedule if one party lives an hour away from the children's school? How much time should a child travel in a car in order to facilitate time sharing? What about extracurricular activities? If the party's geography is far enough to be a problem with time sharing, think about the impact that that will have on the children in order to get them to and from extracurricular activities. F, the moral fitness of the parents. You may ask yourself, what is moral fitness? I would ask you to consider these things. A person's behavior regarding violence, particularly a conviction of domestic violence, dishonesty, substance abuse, conviction of sexual crimes, and child abuse. G, the mental and physical health of the parents. Things you might consider. Have there been mental health issues? Have there been commitments? Are there any underlying mental or physical health problems that would otherwise interfere with a parent's capacity to care for the child? H, the home school and community record of the child. Things you might consider. Are the children involved in outside activities? Do the parents know who the teachers are? Do the teachers know who the parents are? Are people outside of the home familiar with the children and the family? Do they see them interact? What do the actual school records report regarding tardiness, absence, discipline records, grades, and overall school performance? I, The reasonable preference of the child if the court deems the child to be of sufficient intelligence, understanding, and experience to express a preference. Things you might consider. There is no magical age that determines when a child can articulate a preference. It's a case-by-case matter. For me, sufficient intelligence, understanding, and experience to express a preference is typically fleshed out after a few meetings with the child. Tune into the difference between a preference the child has and an encouragement the child might receive from one parent or another. J. The demonstrated knowledge, capacity, and disposition of each parent to be informed of the circumstances of the minor child, including but not limited to the child's friends, teachers, medical care providers, daily activities, and favorite things. Typically, it's easy to determine. You ask these questions. Who is your child's BFF? Who is your child's homeroom teacher? What is the name of the pediatrician? At what dental office is your child seen? What night or time is the dance class? What are the children interested in? What topics? What books? What activities? What's your child's favorite color? K. The demonstrated capacity and disposition of each parent to provide a consistent routine for the child, such as discipline and daily schedules for homework, meals, and bedtime. Typically, this can be determined during observations during your in-home visit. Don't mistake parenting styles with inconsistency. Things to consider. You might have one very strict parent and one parent that's not so strict, somebody that's kind of loosey-goosey. They may also be nervous that you're observing them during a home visit. After observations, you can also piece together the schedule by asking the child and then the parent separately about their impression of what their schedule is, if any, at that home. L. The demonstrated capacity of each parent to communicate with and keep the other parent informed of issues and activities regarding the minor child, and the willingness of each parent to adopt a unified front on all major issues when dealing with the child. Things you might consider. Is one parent making unilateral decisions regarding medical appointments? Is it one person scheduling all of the appointments and telling the other party? Is a third party transporting children to medical appointments before asking the other party if they're available? Grandmother, sister, brother, things like that. Does the other parent know that there's a play next Tuesday? Does the other parent know the child failed chemistry? If the child loses his phone privileges at one parent's house, what happens at the other parent's house? Do they also lose their phone privileges? Does the child know that the parents don't communicate? M. Evidence of domestic violence, sexual violence, child abuse, child abandonment, or child neglect. Things you might consider. What exactly is domestic violence? Is it a fight? Is it an argument? Is it a case that's filed? Just because they have a fight, does it rise to the level of domestic violence? Think about what evidence you might want to rely upon. N. Evidence that either parent has knowingly provided false information to the court regarding any prior or pending action regarding domestic violence, sexual violence, child abuse, child abandonment, or child neglect. Things you might consider. Has one party or the other lied or made up information to get the other person in trouble or arrested? Has either party used calling 911 as a tool to continue their ongoing conflict with the other party? Is one party using well checks without any real legitimate concern as an opportunity to have law enforcement make a visit to the home? If that happens, how does that make the child feel when law enforcement officer appears at the door? O. The particular parenting tasks performed by each parent and the division of parental responsibility before the institution of litigation and during the pending litigation, including the extent to which parental responsibilities were undertaken by third parties. Things you might consider. How has the filing of this action changed the parties' roles, if any? Which party has been more the physical caretaker or the psychological parent of the child during the intact relationship? Post-separation, will either party rely on the extended relative or other provider to care for the child? P. The demonstrated capacity and disposition of each parent to participate and be involved in the child's school and extracurricular activities. Things to consider. Do the parents encourage the child to participate in extracurricular activities? Do they go watch? Has either parent been a coach or a Girl Scout leader or a Boy Scout leader? Will that change? Has anyone volunteered at school? Has anyone attended field trips? Will that change? Think about capacity as the ability to do so, and think about disposition as the desire or interest to do so. Q. The demonstrated capacity and disposition of each parent to maintain an environment for the child which is free from substance abuse. Things to consider. Substance abuse can be self-medicating with alcohol and recreational drugs. Do any of the parents have a history of addiction? Is there any indication that the parents might have relapsed where they are currently abusing alcohol or drugs while the child is in their care? R. The capacity and disposition of each parent to protect the child from the ongoing litigation, as demonstrated by not discussing the litigation with the child, not sharing documents or electronic media related to the litigation with the child, and refraining from disparaging comments about the other parent to the child. Things to consider. What, if anything, has either parent shared with the child? What does the child know? How do you find out what the child knows without telling the child about the case? You sort of sometimes have to tiptoe around that. Has either parent shown the child court documents? Things you might ask the child. Do you know who I am? Has anyone told you what I'm going to talk to you about? Oftentimes, children have lots of questions about who you are. S. The developmental stages and needs of the child and demonstrated capacity and disposition of each parent to meet the child's developmental needs. Things to consider. How old are the children? What are their sexes? Based on their ages or sex, do they have a different relationship with either of the parents? Do they have the need to spend independent time with the parents? Young children's needs, as an example, regarding hygiene are different from an older child's needs. A younger child would likely need more attention. Preparing food for the child based upon their personal or dietary restrictions. Historically, has either parent been the one that took the lead on emotional or psychological support? In that case, has the other parent had the capacity to do so, but just simply deferred? Or does the other parent just really lack the capacity? T. Any other factor that is relevant to the determination of a specific parenting plan, including time-sharing schedule. Things you might consider. Distance between the parties that may or may not allow for children to be exchanged midweek. Extended relatives living in the home. Case specific that you may discover the other factors do not cover.
Hello, my name is Tiffany Ruggiero, and I am a family law practitioner. I am a guardian at Litem, a family law mediator, and a qualified parenting coordinator. Today, I'm going to be talking about parenting coordination and what it is, what it isn't, how you can utilize parenting coordination in high conflict cases, and just a little bit more about it. As a parenting coordinator who is also a family law practitioner, I find that it is a underutilized alternative dispute tool. And I think that that probably is true because a lot of practitioners either, one, don't know a lot about it, and two, courts are not always set up in a way to be able to provide those resources to the practitioners. I will say that the Ninth Judicial Circuit is really ahead of their game when it comes to offering parenting coordination through their dispute resolution center at a discounted rate. But because of the way that the rules and the statutes are set up, it's not always that easy. So, of course, I want to start with the statute. Florida Statute 61125 does outline what parenting coordination is. And so parenting coordination is a child-focused alternative dispute resolution tool. So we're using mental health professionals and legal professionals who have a mediation training to assist in high conflict cases where we're having issues regarding parenting. So they are being utilized to implement a parenting plan by facilitating resolutions of their disputes in a timely manner. As a parenting coordinator, we are trying to educate parents about the children's needs, and then depending on what our court order says, doing other things such as making decisions as to time-sharing changes and things like that in order to implement some of those things. The role of a parenting coordinator is not to make major decisions about time-sharing, to change time-sharing. We are not in the position to change parental responsibilities. That's a judicial function that we do not that we do not carry. However, there is a really handy list that I put together of how, as a parenting coordinator, I can be given authority by the courts to resolve and make recommendations about issues. So healthcare management, what doctors are needed, how often a child should maybe see a therapist, things like that. Child rearing, education or daycare, if parents are having a dispute about what they want to do as far as where they send their child to school, what daycares we can help assist with that, enrichment and extracurricular activities, religious observations and educations, travel, passport arrangements, communications between the parties regarding the children, roles of and contact with significant others and extended family, substance abuse assessments, or testing for either or both parents, parenting classes, etc. It's no surprise that the impact of high conflict cases on kids is dire. It's severe. It can be absolutely traumatic when children have to go through high conflict cases. And even kids who survive the divorce, however, can still not come out unharmed, right? We can see chronic high conflict fighting that occur between parents that leave scars on children well beyond the age of majority. So I believe that the Florida legislature took a lot into account when making the statute for parenting coordination, because that's just a reality of high conflict cases. No surprise to say that chronic fighting between parents can erode a relationship between the child and another parent, and the children who tend to experience high conflicts in a divorce setting can suffer psychological and social problems. So the overall objective to parenting coordination is to assist in those high conflict parenting issues and to help them implement a parenting plan, to monitor that they're being in compliance with the parenting plan, and to resolve conflicts regarding their children and the parenting plan in a timely manner. Obviously, because we are child focused, we are looking to maintain the children's safety and well-being while also making sure that they have a healthy and meaningful parent-child relationship. It's quasi-legal mental health, alternative dispute resolution process, and it combines a lot, such as assessment, education, case management, conflict management, and sometimes even decision-making functions. Our role as a parenting coordinator is more frequently reserved for those really high conflict cases. Typically, we are appointed by the court unless the parties have come together and made a determination that they think a parenting coordinator would be beneficial in their particular case. A high conflict case would be one where the parents have demonstrated that there has been a long-term inability or willingness to co-parent. We see them all the time. That's where you're probably going to get the best use of a parenting coordinator or an appointment of a parenting coordinator. When you see parents that are unwilling, or cannot comply with court orders, that they are not able between the two of them to reduce their child-related conflict, and if they're not able to protect the child from the impact of that conflict, then it is a good idea to maybe entertain a parenting coordinator. One of the things that they really wanted me to address with you guys is how parenting coordination and domestic violence kind of go hand in hand. So pursuant to the statute, if there has been a history of domestic violence, the court may not refer the parties to a parenting coordinator unless both parents consent. Again, it is all about safety. One, safety for the parties involved, but also safety for the parenting coordinator. The courts shall offer each party an opportunity to consult with an attorney, a domestic violence advocate, whichever they have available or whichever they choose, before consenting to a parenting coordinator entering the case where there has been domestic violence previously. The court must determine whether each party's consent has been given freely and voluntarily. If at that point the court deems that a parenting coordinator would work for this case, then they can enter an order. But those are the steps that need to be completed first before there is a parenting coordinator assigned to a high conflict case. So I wanted to talk a little bit about the Florida Supreme Court opinions and rules. In July of 2014, the Florida Supreme Court entered opinion number SC 13-1751, in case you guys want to look it up, wherein they revised some of the family law rules or procedures, specifically 12.742, as it applies to qualified and court-appointed parenting coordinators. The administrative order provides an application and process for us as parenting coordinators who wish to be considered qualified within each judicial circuit. So it's important to note that every judicial circuit has their own requirements of what it takes to be on their qualified list. Obviously, the statutes and the rules lay out what you need, how many hours of training you need, that you need to have a mediation background or be a mental health professional or an attorney. So those are all laid out, but every single circuit has an independent application that a parenting coordinator who's already checked those boxes will need to do in order to become qualified. They're very similar applications, but if I am, for example, qualified for the Ninth Judicial Circuit, I need to do that for every circuit in which I practice. So just because I'm qualified in the Ninth doesn't mean I can go and be on the qualified parenting coordination or coordinator list for Seminole County. It's a different circuit. I have to follow their application, which includes a background check. And of course, I have to provide to them all of those boxes I was talking about previously, when I checked them off, what I did, what courses I took, etc. So Florida Family Law Rule 12.742 talks about the qualification process, and it states that each judicial circuit shall establish their own process for determining that a PC is qualified in accordance with the statute. So if you were looking for a qualified list of parenting coordinators, go onto your circuit's website. Most of them have them up. If not, if it's not readily available online, my recommendation would be to call whatever ADR or dispute resolution department that they have for the circuit, and they should be able to email them to you. I believe the Ninth Circuit does have their list up, but for other neighboring circuits, if they don't, then they can email them to you. The rule also states that the order referring the parties to PC must be in substantial compliance with the Florida Family Rule of Procedure 12.984, Section A. It must specify the role of the parenting coordinator, the responsibility of the parenting coordinator, and the authority of the parenting coordinator. And so that kind of ties into what I was saying before. I made a list of things that a parenting coordinator can do. A parenting coordinator can do what's in their order. So the order really needs to be specific as to what the issues are that the court really wants the parenting coordinator to focus on. It can be very broad. It can be very detailed. Depending on what the order says will depend on how I or a parenting coordinator will tackle that case. The rule also talks about appointment of parenting coordinators. Obviously, the parties may agree in writing on a parenting coordinator subject to court's approval. If they cannot agree, a court shall appoint whichever qualified parenting coordinator they think would best fit a particular case. The parenting coordinator then must file a response accepting or declining the appointment. Obviously, we'll talk a little bit about some of the rules that go along with being a parenting coordinator, but no surprise, conflict of interest is one of those things that we need to make sure that we're complying with. So that would be a situation where you would potentially see a parenting coordinator decline. Maybe they've worked with these parties before. For example, maybe I represented a party in a previous case, so that would be a declination on my part in response to an order appointing me as a PC on a particular case. The initial term of service shall not exceed 2 years. And that's a really long time. I don't know that there's a specific guideline for guardian ad litems as to how long they can be on a case. But for a parenting coordinator, you're 24 months in and out unless there's an order extending or an order telling you that you have been relieved of that duty. and your service should be terminated by the court if for some reason the PC resigns or is disqualified, or if there's a finding of good cause shown on the court's own motion or on a party's motion. So good cause would be, again, if a new occurrence of domestic violence has come in. PCs really, we really don't have parenting coordinators in those situations, because at that point we're now party focused and making sure that they are protected. If there's any type of situation that may compromise the safety of any person or the integrity of the process, then the court could at that point terminate the appointment. So the next thing that the rule talks about is authority. So with express written consent of both parties, the parenting coordinator may have temporary decision-making authority to resolve specific non-substantive disputes between the parties until such time as a court order is entered modifying the decision. So a pickup time, a FaceTime nightly window, those are things that we can do on a temporary decision-making basis. We have the authority to make recommendations to the court concerning modifications of the parenting plan or time sharing. We have the authority, with the express consent of the parties, to have access to confidential and privileged records, informations of that party. So whether it's a mental health record or a medical record or anything like that, if we have been given written consent, we can have access to those. And then if we've been given express written consent, we can have the parties provide confidential and privileged information regarding to their actual healthcare providers, so that we're not in violation of HIPAA and those healthcare providers can provide us information. Same for any other third party. With the express approval of the court, the parenting coordinator may have access to the child's confidential and privileged records and information. That's typically in a court order, because then we're getting a full view of exactly what's going on. And then from there, we're able to assist the parties through their conflicts. Also, if it's approved through the court, we can be provided confidential and privileged information that is concerning the child's health. So whether that's information from a child therapist or psychologist or occupational therapist, depending on what's in our order, if the court gives us express consent, we can get access to those documents. So it seems pretty broad, but we as parenting coordinators are limited, and the rules do express how we are limited. A parenting coordinator shall not have decision-making authority to resolve substantive disputes between the parties. So the rules lay out that a substantive dispute would be one that significantly changes the quantity or decreases the quality of time a child spends with either parent or modifies a parental responsibility. Now, I want to take a moment to kind of talk about that. If I have a court order that says I'm supposed to be working with two parties to help create a parenting plan, then I would do that. If my order doesn't specify that, what I can't do as a parenting coordinator is say, Dad, you're just not listening. You're not doing the things that I want. So instead of seeing the child every other weekend, you're going to see them once a month. I don't have the authority as a PC to be able to do that. I also don't have the authority of a PC unless I'm given consent by a judge to modify parental responsibilities. I can't do that. A parenting coordinator shall not make a substantive recommendation concerning parental responsibility or time sharing to the court unless the court on its own motion, or there's a joint motion between the parties that state that there's been an emergency regarding parenting, the recommendation would be in the best interest of the child, or that the parties agree that any parenting coordination communication that may be raised to support or challenge the recommendation of the parenting coordinator, then those can come in. So emergency situations, if it's in the best interest of the child and the court says, hey, I want you to come in and give me your recommendation on what we should do for time sharing, then we're able to do that. But typically, per the rules, parenting coordinators shall not be called to testify or to be subject to discovery rules unless the court makes a prior finding of good cause. There are rules for qualified and court-appointed parenting coordinators that I want to go over with you guys just briefly. The rules detail the applicable standards while defining what a PC is and what concepts are utilized. It requires us to do a lot of things. First, we need to be competent in the professional sense of the word, but we need to obviously do our continuing education so that we are remaining competent about how to adequately assist in high conflict cases. If for some reason we find that we are over our head with this particular situation, our expertise does not lend us to be able to help these parties, then at that point we'd be required to withdraw. We have to maintain integrity, and the rules for qualified parenting coordinators makes a very detailed list of how we do that. Obviously, avoiding dual relationships. We're not supposed to accept appointments if there's been any prior personal, professional, or business relationship with any of the parties. It's kind of like our conflict check. PCs shall not allow their personal values, morals, religious beliefs to undermine or influence the process. We shall not engage in any appropriate activities or misrepresentation. Obviously, we're going to need to be patient and dignified and courteous during the process. The rules go on to say that PCs shall inform the parties of any risk before making substantive recommendations and their right to independent counsel. So if I'm going to suggest that they try a different location for pickups and drop-offs, I got to let them know, hey, this is a high traffic area. These are the potential risks and pitfalls by making this change. And then, of course, I got to give them the opportunity to independently consult with an attorney if they would like to regarding any of the changes that I recommend. Obviously, we must remain impartial, and if we cannot, we must withdraw. Again, this is an ADR, a dispute resolution process, so some of these are going to be similar to what a guardian ad litem or a mediator would be required to do. A PC shall not serve if there's a conflict of interest. I talked about that a little bit before. Whether the conflict is known at the time of appointment or arises later, at that point, as a parenting coordinator, we should withdraw. A parenting coordinator shall schedule sessions in a manner that provides adequate time for the process. So for me, I typically schedule most of my meetings for at least 45 minutes to an hour. They can be individual, but depending on the specific needs of the parties, it does make sense for us to do some things together. And I do also think that there is power in doing things apart. So having that initial meeting will kind of give me an idea of exactly what would be best for the parties and how I can serve them. And it's really important. You can use technology. I think that's shown a lot of alternative dispute resolution situations. At the last Florida ADR conference, ODR, online dispute resolution, was a really big topic. And using technology for parenting coordination, even as we're making adjustments, for example, in the face of COVID-19, you can get on a Zoom call with both parents. I can get on a Zoom call individually with the parent. So I would recommend using technology. I think that also avoids any issue the parents have if for some reason we have a prior court order that doesn't allow them to be face-to-face. So we want to make sure that per the rule that PCs are scheduling sessions in a manner that give enough time for the actual process to take place. Obviously, we maintain confidentiality of all communications, and unless there's a court order otherwise, things remain confidential. Prior to the initial meeting, PC shall provide written notice of their fees, their costs, their methods of payment and collection, and if that changes during the course of your PC appointment, you need to update that with the client, and they do get an opportunity to review that with an attorney. It's our job as parenting coordinators to make sure that on the onset that we review the terms of all of the court orders at the initial meeting so that we are all on the same page on what the court order says, what your prior parenting plan says, so that there's no confusions. Also, parenting coordinators shall monitor the process for domestic violence. So if we get an inkling that things have kind of picked up, then obviously that's something that we need to address. We're also monitoring the process for substance abuse issues, mental health issues. If there is an injunction, a domestic violence injunction in place that limits how the parties can communicate and be around each other, then we need to honor those terms. Again, technology works really well for that. If I have an injunction where parties can't be within 500 feet, I can't have them both come to my office, but I can still have them both interact via a video conferencing platform. If for some reason we believe as parenting coordinators that there is domestic violence or substance abuse, then at that point we need to suspend our process and notify the court. So the Florida Supreme Court has come up with a bunch of forms that are on their website. If you are looking to appoint a parenting coordinator, there's the order of referral, there's the response by the parenting coordinator. If there's a need to report an emergency, which I just kind of talked about, there is a family law court form for that, and also a request for a status conference. Usually we would utilize those if we feel like we're not getting a client to comply or come to meetings or pay their costs, things like that. Parenting coordination is a very underutilized alternative dispute resolution tool. Sometimes I tell my clients, if you guys have high conflict, that means I could step outside and point to the color of a car that is clearly black, and you guys would come up with two different answers. What a PC is trying to do is to get you guys through different methods somewhere on the same page, trying to come up with ways to alleviate the conflict, whether that is pickup and drop-offs happen at school so that we're not picking up and dropping off at a Walmart, thus having to get into a verbal altercation. FaceTiming at night. Maybe FaceTiming at night needs to happen in the child's room where another parent is not there, so the other parent doesn't feel like the parent who has the child is interfering. So as small as those little things seem, those are the things that cause the most conflict in a family law case, is the little things that we assume that reasonable parents would be able to work out, but unfortunately these particular parents cannot. So I'm sure that Ms. Hall is going to be able to give us any questions that people have when they watch this this presentation. So if you guys have questions about parenting coordination that weren't answered, please feel free to reach out to Ms. Hall and she can get your questions to me. Thank you.